we can get this guy done.
Give me a name. Did you hear that? You keep that file?
I still have it over there. I'm not used to being.
John, there's no PSI.
Yeah, there wasn't supposed to be. All right. Good morning.
Oh, I'm sorry.
That's all right.
I brought a court record check about experience on behalf of Mr. G. Today's the date, time set for sentencing, Your Honor. Mr. G is ready.
All right, so we've got November 11/25, failed to display valid license. And we've got an October 28/25, possession of unregistered firearm. If I remember correctly, when I took the pleas, I told Mr. G to have G or G? G. I told Mr. G to have some kind of life plan when he came back, right?
Yeah.
What's your life plan? How old are you? All right, what's your life plan?
Basically, when I get up, I was gonna try to get my CDL and start down when I get out.
Get out of where?
I was on my target sentence when I got out of jail. I was gonna try to get my CDL.
I told you have a life plan or you'll probably go to jail. That's what I told you. Have a life plan or you'll probably go to jail. So I wanted you to make my tail wag by telling me what your plan is. So you've been waiting since, when was that? So you've been waiting till March to come back to go to jail? Brother, if I wanted you in jail, I would have sent you to jail that day. I gave you time so you could put together a plan. I think I said something about if you don't have a plan, I'm going to make a plan. Something like that? Who you got with you today? Your dad? Okay. Can I talk to Dad?
Yeah.
Dad, you mind coming up? Remind me, where'd you go to high school? Yeah, did you graduate? Okay, how far did you get?
So,
12. Dad, just state your name, because you're going to talk on the record. Just state your full name. Thank you. He living with you? Okay. Are you happy with where he's at in life? Okay. I'm gonna guess you haven't been happy with that for a while. Okay. All right. Are you happy with where you're at in life? Honest. Be honest with me. You got any big dreams? Anything you want to accomplish? Any place you want to go? Anything you want to own?
Yeah.
Tell me. What? Tell me.
Start making music.
You want to start making music? When? Oh, okay. All right. Okay. What kind of music you make? I mean, you sing, you play drums, what? Oh, electronic.
Yeah.
Okay, that ain't my thing, but okay. All right. How you pay your bills now?
I work on my dad and his girlfriend.
What do you do?
Surgery centers.
Okay. Okay. I'm prepared to put you in jail. I don't want to put you in jail. I didn't want to put you in jail in March. But what I don't like is what I see is what appears to me to be you're healthy, right? You're as healthy as you look?
Yeah.
Okay. It's offensive to me to see what I think is a healthy 21-year-old that doesn't seem to be doing much with his life. That's offensive to me. So give me, how many hours did you work last week?
It was like 8 hours. 8 hours.
8 hours. Okay. How many hours did you work on your music last week? Okay. So all told, last week, you spent 20 productive hours. That's offensive. That's offensive. Healthy 21-year-old man, you should be working 60-hour weeks right now, building for your future. So here's where we're at. You want me to give you jail time today and you're on your way, or you want me to give you some time to come back with a plan? You're going to jail unless you can come up with some positive use of your time. Because, brother, you're taking oxygen that the hardworking people in this world need. What do you mind if I ask you a question? How old are you? Where do you think you're going to be at 49 years old? Speak up. Give me an idea what you think you're going to be doing. You're going to be a millionaire. No freaking way, dude. No freaking way. No, it's what I know. And I'm going to tell you why. The only way you're going to be a millionaire at 49 with your work ethic is if you happen to hit the lotto. There's not a millionaire now anywhere on the globe that at 49 is a millionaire, at 21 works 20 hours a week on his future. Not one. That is not the way it happens. Dude, your life is not determined by what you want. It's determined by the decisions you make, the choices you make. First thing you need to do is go out and finish your education. Get your GED. Then get yourself a job that's more than 8 hours a week. So once again, I'm going to put the question to you because I got a lot of files today. You want to be sentenced today, or you want me to give you a little bit of time to come back with a plan? Dad, I'll listen to anything you got to say.
Yeah, stuff together for at least.
I don't know if he can, but I'm willing to give him some time to try. Does he even listen to you?
Yes.
Good. There's hope for you. How much time do you think he needs to put together a plan that'll make my tail wag? Give me a date.
May 14th.
That enough? May 14th is only about 3 weeks, 4 weeks. Dad, June what? What time, ladies?
8:30.
Thank you.
You're welcome. All right, we'll see you guys back here. We'll get you a notice. Thank you, Dad. You wanted her, Emma.
Something.
What else we got? Evans, come on up.
Good morning, I'm here, Josh Adley, on behalf of Mr. Arthur Evans, who's stating his name correct. I'm set for sentencing on this matter.
Good morning.
Stating it correct.
All right, you gentlemen had a chance to go over the report recommendation?
Absolutely. We reviewed the report recommendation. We got no additions, deletions, corrections. We asked the court to adopt the recommendation in whole.
Okay.
I know Mr. Evans has some concerns about ability to comply due to new employment he gained.
Where are you working?
Great job. He's going to do an out-of-state road work. Yeah, out-of-state road work. So the first gig's going to be in Ohio.
Okay.
So Emily, I think that the ETGs or how we're going to handle testing, there's a way to do this. So I don't think that this is going to be a complete impasse. I think getting
Right.
the 40s a more program schedule,
Mhm.
he's going to have to time that. That may take a little bit of creativity to get that. He's back in Michigan for some
We'll work with him.
time.
So if you know, are you going to tend to be like, you're still going to be living in Michigan, but you're just going to go out for these jobs, come back, this is home base?
Yes.
All right. So do you have any idea, like your usual deployment will be for 2 weeks at a time and you'll be back, or do you know?
Yeah, so, we're starting out in Ohio, I should be coming back every day, and then after we move to either Pennsylvania or Philadelphia, it'll be 3 weeks on, 1 week off.
Okay. Do you have any idea when you'd be moving out of Ohio? Okay. Well, here's what I'm going to suggest. Get as much of the boots on the ground stuff that I'm telling you to do, get that, as much of that done as you can before you go to Pennsylvania. We're going to do whatever we can to work your probation around your job, because we don't want, this sounds like a great job. So we don't want to cost you this job. All right. Now I got to tell you this, he probably already has, but I'm going to tell you this. You're under my thumb for, what do we got, 6 months. So you're under my thumb for 6 months, right? The way to get out of this without being hammered is communicate. If she, I don't care what the problem is we have, if she comes to me, she being Miss Troll, if she comes to me and says, Judge, he's great at communicating with me. He's trying everything I give him to do. He's really making a good effort to be a good probationer, then I'm going to give you grace. All right. If she comes to me and says, we got this problem, and I can't get a hold of him, he seems to have changed his number and he's just doesn't seem to be walking the walk, then you got a problem. But as long as you're making a good faith effort to comply with probation and you're communicating with her, if we got to extend your probation a month just to get some boots on the ground stuff done, whatever we got to do, we'll get you through successfully. All right. Because that's our goal, is to get you in a probation clean, successful completion and be on your way. Okay. That makes sense. All right. So let's get back to sentencing. Was there anything else before I sentence?
No, you are. I think you've been getting away the allocution. This individual's been an open book. He's been humbled, accepted responsibility, understands how serious like this could be, and get by the grace of God.
Yeah.
Just I have a lesson learned.
Yeah.
Well, it won't be receivable.
All right.
What's that? Well, and yeah, as he said, obviously we should give him a thought on that. Again, it would go without saying, right? He should not be drinking because that's been one of the bond conditions. He's actually done. He's not drinking. He's got issues. The incident.
Pick it up.
Stay it up. I can't hear you.
I said, and I do not believe I will start drinking,
Good.
but I got out of my life and believe it's gonna drink.
And you learned something important young enough to make some changes. Good for you. All right. Anything else you want me to know?
No, I'm the best be engaged, which I can.
Yeah, I don't want to sound like Yoda, but there is no try. Either you're going to communicate or you're not.
Yeah.
Right? I mean, it's not like you got to get her on the phone. You're going to have her email. So, you can email her at 2:00 in the morning, right? Anything else?
Yes. All
right. So I'm going to go along with the recommendations. I'll adopt those in full. I am going to order the 4 days on the work program. Once again, we'll work with you on your scheduling. To whatever extent possible, let's get those days done before they got you, in Pennsylvania. Total fines and costs, $1,300. Can you pay all that today? When you get downstairs, talk about your options. Any questions? Good luck with the job. Mr. Bolahanis, who do you have?
Jacob Kozakowski,
Kozakowski. And did I hear you tell somebody he's in custody or is in treatment somewhere?
he's in Rushton Recovery, Your Honor.
Where's that at?
It's in New Haven.
I don't think I know them. Are you familiar with it?
I'm not familiar with it. I was notified this week.
Well, I'm actually encouraged that he's in treatment somewhere.
Yeah. That's exactly what I was gonna say, Your Honor.
Any idea how long he's in treatment?
Yeah. So we were hoping.
That June date? Yeah. Yeah, I'll just make a note that he's in treatment today and we're going to reschedule for June 25.
And Coach, Your Honor, just very briefly.
Yeah, you can. What time are we going to do that one?
9 a.m. was fine.
Come on over here so it's not a record.
Yeah. I don't know. I don't have a problem shaking it. Oh, that's.
Yes.
No, I thought. What does kid have? 1.5%. Yeah. Yeah.
Whatever the phrase, that it wasn't honorable, wasn't just, it was something. Definitely open. Well, hopefully he's getting treated. of checking something. I'm pretty sure I know this kid's Bob. Pretty sure I know this kid's Bob. It's going to say. It hasn't made sense to me. What is that? Person mark. But. Yeah, we said close. No,
Yeah, I'm easy, I'm.
Yeah, I got, just so, I got you. Thank you so much, John.
Yeah.
Well, Hannah, no.
Yeah. Okay, so adjourn, you're welcome. Adjourn to June 25, 9 AM. Heather, did you catch the name of the program?
Sorry.
Did you catch the name of the program you said? Rushton, thank you.
It's going to be known when it's left.
Good morning.
Mr. Taylor.
Mr. Taylor, how are you? Excellent. Are you going forward today without an attorney?
Yes.
All right. And have you looked at the report and recommendation of sentencing?
Yeah, I saw it.
Okay. Was there anything in that report? Oh, we don't have a report for you. Why don't we have a report?
Actually scheduled this one.
Oh, he came in for a PSI today.
He's on probation when he was sentenced at the end of January.
For? Oh, okay.
He is engaged in treatment at Higuera.
Good, good.
Jail, because we had an issue with the work program.
Okay.
But testing without incident, engaged in treatment. So my recommendation would be that we just run concurrent.
Okay. All right. And you're going to go along with that? Yeah. You working now? Where do you work?
I remember I'm AFAC certified. I work for a company, but.
What do you mean you don't work? You're self-employed?
Yeah.
Oh, okay. Yeah. So you work for a company, but it's yours.
Yeah.
Gotcha. Gotcha.
But it's not established.
Keep.
You don't see her.
Okay. Why not?
No, I don't know. I said one of years ago back in my.
Brother, it's so much protection for you. Yeah. You should really look into that.
I will.
Yeah. Yeah. You keep them busy though?
It's been pretty slow. It was nice during the winter time, but it's been pretty slow.
Okay.
Yeah, I'll maybe do it.
Okay. All right. So what are you suggesting? 12 months concurrent? You got a case number on the other one?
6-0095.
That's this one. And
Oops, I apologize. 25-0704.
I'm sorry, one more time. 25 dash.
0704.
Okay. All right. All right, let's just do $1,000 fines and costs, concurrent probation on the other terms. Can you pay that today or do you need to talk about options? Go downstairs and you know how to do that then.
Yeah.
All right, get that taken care of before you get out of the building. Yeah, actually, it looks like you already owe us, just under $2,000.
Yeah.
So you're currently making payments? Just roll it all in. Roll it all in. All right, good luck to you. No, just fine.
$1,000.
Yeah. All right. All right, good luck.
Yes, sir.
and what about the restitution, the OUIL? Who's Romulus? How much is Romulus?
You still need it?
No,
100.
Romulus would be 200.
Are you guys ready? Are you waiting for an attorney? What are you doing?
That's a right there.
Oh, the attorney. What's your name? What is it?
For sentencing, Your Honor.
All right, I got your file ready. Just waiting for your attorney.
Oh, Judge. That's not, I think I do.
Oh, but you know what? That's all right. Let's do that all then too, because if he comes back with the kind of attitude I had today, he might not be doing that.
Sure, okay.
It's like, I don't know how to get that in touch with reality.
Somebody mentioned that, he goes, I was like that guy by doing the Navy. Usually you,
I'm pretty sure I talked to him about that the last time he was here about the military. I'm not 100%, but I think he might be one of the kids that I told him go over on Ford Road and go talk to the recruiters.
Jill, didn't you break that needs to be fixed over?
Oh, she cannot figure it. I got Mr. Gibson here.
Gibson, come on up, sir. What's Mr. Gibson scheduled for today?
I think it's
Are
short.
you William?
Sure.
Oh, I got you right here. Are you going forward today without benefit of an attorney? All right, let's see what we got. All right, I've got a file from August. Failed to display a valid license. Let me see what the paperwork says. All right, so I ordered 4 days on the work program back in September. Failed to comply with that. We gave you another scheduled 4 days. You did 1 day, had problems with that. So I gave you 18 hours community service.
Oh, no, sir.
All right, you got paperwork? Awesome. Where'd you do it? That's not gonna count.
Why, put it in downstairs.
What's that?
Put it in downstairs.
They gave you a steno pad as proof of community service?
No, it'd be a paper to call them and work it out and I'll call them. And I did hours. You can call them right now. I did all the hours. I did all of them.
Okay, but that's not the way community service works. The way the community service works is you're supposed to bring me paperwork from the charity that shows you did the hours. Absolutely. Go back and get it. That's fine. Their letterhead that says on this day. Yeah. I'm telling you, get paperwork from whatever the charity is that says you did it X number of hours and that X has to be as many as I ordered.
No, they got more. I did.
All right. I'm not calling you a liar. I'm just telling you the way it works is I got to have paperwork from the charity. So can you do it today?
Yeah, I'll put it right in.
Come on back. Come on back. Your file will be right here.
It's what, it's the letterhead done, right? The state has.
Letterhead from them with your name on it that says you did 18 hours or 20 hours or whatever.
You get to the right place if you did that a rec on.
Is there set a rec center?
Yeah, he said I went to the rec
I don't
center.
think it is, I don't think that's,
No, he said I went to the rec center and
I didn't hear what rec center he said, but
maybe he went and worked out there. I don't know. Yeah, he said rec center.
Well, I didn't even question where he said, because he said they gave it to him downstairs. So I figured it was something off our list. And I know we don't have a rec center. on our
Right,
list.
yeah. That's what I thought. I heard it was rec.
I heard rec center too.
For my boss, like looking for my boss. This is normal shit. Scans.
Oh, where is she?
I don't know. She was here a second ago.
I like her better than
I know. That's why I'm going to find her for you, Judge.
thought I'd point that out, but go ahead. I'll hear.
Thank you, Judge. We likewise do not believe that a conflict exists, but should a conflict arise, we would waive said conflicts for any and all cases before this honorable court today. Ask this court to please hear them, Your Honor.
The court, for its part, also does not believe that there's a conflict either in the court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Derek Stewart.
Morning, Your Honor. Raymond Cook, the evening.
Stewart. George.
Stewart and, Stewart, we're just waiting for your attorney to enter the courtroom. Well, before we go ahead, is there a new report in Mr. Short's case?
Joy Gaines, Senior Assistant Public Defender. Yes, there is, Your Honor. We received a report last week before last.
Because I don't have a copy of that report.
I can,
Was that a report finding him competent?
that is correct, Your Honor.
Can you send that, let me pass it briefly, send that to Ann. She'll get it to me and that way I can review it and we can handle it today.
Okay.
All right. Mr. Stewart, I'm going to pass your matter briefly, okay? All right. Thank you, Mr. Stewart. Court calls the case People versus Wilnisha Crosby.
Morning, Your Honor, Ashley Phelps for the people.
Morning, Your Honor. Assistant Public Defender Davi Lebo, form is Crosby, and I do have a green sheet.
All right.
Good morning, Your Honor.
Crosby,
Alicia Crosby, how you doing?
I'm doing great. How are you?
Okay, could be better.
Yeah, I got it. I don't even know why I asked, right? You're seeking to adjourn this?
Yes, Your Honor. I've reached out to the Wayne County Jail and left a message, but unfortunately, I haven't yet been able to actually have a meeting with Crosby.
And how much time did you need? 2 weeks or 3?
I would hope we could get this done in 2 weeks, Your Honor.
Probable cause conference in this matter then will be adjourned to May 7th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you.
Reason.
Court does call the case People versus Anthony Reeves.
Your Honor, Raymond Cook.
Yeah. Or Alan can get it. I'm sorry. I didn't mean to.
Yeah, Robert, go off after Anthony Reeves. Anthony, would you state your name for the record?
Yes, my name is Anthony Lamar Reeves.
Thank you, sir.
Judge, I don't have all the discovery yet. I should have it this week. Hopefully I can arrange a visit with Mr. Reed in Lapeer, the correction facility. Could we adjourn? Is it possible to adjourn this out about 3 weeks?
I want to adjourn.
I'm sorry?
I don't want to adjourn. I want to go for a dismissal.
You want
Want to do what? It can't be dismissed at this point, sir.
You say it can't?
It cannot, but your attorney is indicating he doesn't have all the discovery to be able to talk about the case with you.
Well, I ain't got a chance to can I get like a second to talk to the attorney before y'all adjourn? Because I don't really want to adjourn this to 3 weeks.
Okay.
Mr. Reeves, if you would let me adjourn it maybe 2 weeks, I could hopefully set a visit for you and get you the discovery. I know you're anxious to deal with this, but you and I need to talk about the case.
How about 1 week, man?
Well, I can't do 1 week. This isn't a negotiation, really. I can't do 1 week. The shortest period is 2 weeks because we have to do a video writ for you. But that's the best. If you're looking to speed this up, that's the best we can do.
All right.
Probable cause conference, May 7th, 2026, 9 a.m. Beth.
Thanks.
Court calls case People versus Toreno Rogers.
Morning, Your Honor. Raymond Cook for the people.
Torino Rogers, John.
Assistant Public Defender Davi Lebo on behalf of Mr. Rogers.
Mr. Rogers, state your name again, sir.
Torino Smalley Rogers, John.
Thank you, sir.
Your Honor, I'm going requesting adjournment. I have not been able to meet with Mr. Rogers, however, I do have that set up for tomorrow.
You what?
I do have that set up for tomorrow.
Tomorrow you're going to meet with him?
Yes,
So 2 weeks would be good.
that'd be perfect, Your Honor. Thank you.
7, 2026, 9 a.m. Bond continue. Court does call the case of the People versus Evan Sherbert.
Morning, Your Honor. Raymond Cook for the people. Assistant Public Defender Davi Lebo on behalf of Herbert.
Sherbert, can you state your name, please?
Again, Evan Sherman.
All right, I have before me a plea form. Is that what we're doing today?
It is, Your Honor.
Plea form indicates that the defendant will be pleading to the stated count to receipt concealment of stolen property, 200 to 1,000. That's a 1-year misdemeanor. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Correct, Your Honor.
All right. Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, please.
Evan Sherman.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Still wish to plead guilty?
I couldn't hear you, I'm sorry.
You still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Yes.
I didn't hear you, sir.
I couldn't hear you, I'm sorry.
Okay. To that charge, how do you plead?
Guilty, Your Honor.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or had one signed on your behalf. Is that correct, sir?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
I do not, Your Honor.
You understand that you're waiving all those rights, including your trial rights, which are contained in paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty?
Yes, Your Honor.
September 3rd, 2022, at the location of 9429 Main Street in Northfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of this offense?
I went to the storage locker and taken some items, brought them back home.
You are echoing there. So you rented the storage locker. Did you have stolen items in that storage locker?
They were at my house. From the storage
So
locker.
at some point you came into possession of stolen property.
Yes, Your Honor.
Is that correct?
They were found.
All right. And you knew that it was stolen.
Yes.
All right. And you tried to conceal the whereabouts of that stolen property from its rightful owner and or authorities. Is that correct, sir?
Yes, Your Honor.
All right. And was the value of the property that you were concealing, was that in excess of $200?
I believe so, yes, Your Honor.
All right. Counsel, you'd stipulate to the value being over to.
Yes, Your Honor.
Yes, Your Honor.
All right. Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
May 18th at 9 a.m.
May 18th, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue.
Thank you, Your
Thank you, sir.
Thank you.
Court does call the case of the people versus Derek Braddock.
I am here.
Half the people.
Assistant Public Defender Davey Lieb on behalf of Ms. Braddock, and I do the green sheet.
Ms. Braddock, did you state your name?
Yes, my name is Derek Braddock.
Do you have a camera, please, ma'am?
No, my camera just currently broke. My son just currently broke it. I mean, my back camera works.
I'm going to adjourn it this time, but if you don't get a camera fix, you can't appear by Zoom. You got to come down to the courthouse. You understand that?
I understand, yes.
You have not received discovery. Is that the issue?
I have received it as of this morning.
That's part.
I received it this morning.
Got it this morning.
Yeah.
Okay. Probable cause conference will be adjourned to May 14th, 2026, 9 a.m.
Thank you.
Thank you.
Thank you.
Thank you.
Yeah.
Court does call the case through versus Jason Maples.
Morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Maples. Mr. Maples is approaching. Would you please state your name for the record, sir?
Jason Gary Maples.
Your Honor, this morning we have been able to finalize a resolution for a plea agreement in this matter, which would allow Mr. Maples to continue in the felony recovery treatment court. We just got the information moments ago that it would be that the plea agreement we are negotiating is appropriate. So we're asking for an adjournment in order to formalize it in writing. There is also a stipulated order for Mr. Maples to be released.
Follow that, correct?
Yeah, Your Honor.
So what I will do is, back to some custody, I'll turn it out 1 week to 30th, April 30th, 2020.
Thank you.
Bond will continue. Thank you. Court recalls the case of the People versus Derek Stewart.
Raymond Cook for the people.
Order, Joy Gaines, Assistant Public Defender, represent Stewart.
Mr. Derek Stewart.
Stewart? Okay, thank you, sir. I now have this report. Do the people have any additional evidence?
No, Your Honor, we would stipulate to the report.
We would stipulate to the report as well. I also believe I submitted a proposed order. But
Yes, ma'am. The court, in reviewing the report, and that being the evidence, it would find that at this time the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings and can rationally assist in his defense. Therefore, the defendant is deemed competent. I have signed the order. What would you like to set for?
we would like to set up for a preliminary exam.
He is there, sir.
Yes, that is correct.
What is my 3-week date? So,
Grateful.
is all discovery complete, Ms. Gaines?
That is my understanding.
And would the people have their witnesses available May 12th?
Is that 3 weeks out, Your Honor?
That is 3 weeks.
That should work. We'll do the best.
All right. Preliminary examination in person, May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court does call the case, People versus Jenny Liu. I'm sorry.
Your Honor, Keith Clark. Oh, there we are. Your Honor, Keith Clark, Assistant Attorney General on behalf of the people.
Good morning.
Good morning, Your Honor.
Federal Judge Torshov, Assistant Public Defender on behalf of Ms. Jenny Liu, who should be present on Zoom, Your Honor.
You have her? Did not have her.
Your Honor, my office did speak to her yesterday. She indicated she'd be here. I do not know why she's not present. For the record, I'm pushing adjournment, but I do not know where she is.
You're asking for an adjournment. You don't know where she is.
No, Judge.
Go ahead.
Your Honor, we did receive information. I shared it with Defense Counsel yesterday. that Miss Lou, after she was given personal bond, took a flight and left the country. Not left the country, I'm sorry, left the state. She sent what's called a JPay message to a fellow prisoner, or who was a fellow prisoner at the Department of Corrections. She was hopping on a plane and leaving. I can provide that to the court. We have prepared a protective order. Some of the information in this, some of the discovery in this case would be a threat to community safety or to the safety of the prison. So there is a protective order. Hopefully, counsel has a copy that the court can sign, and when the court signs the protective order, I will provide all the discovery to the defense.
I'm sure we have it in our file, Judge. I can print that out and give it to the.
Okay, you can give it to, say, I understand. And I would sign that protective order, but her not being in the representation, what is the bench warrant for the defense press time because it, but the court is gonna, that bench warrant will issue no bond.
Thank you, Judge.
Thank you, Your Honor. And Your Honor, I'm sorry, the court issued the bench warrant, and the bench warrant was for no bond?
No bond, sir.
Raymond. Thank you, Your Honor.
Thank you.
Bond?
Yes. And then immediately. That warrant will issue immediately. Court does call the case of the People versus Abdurrahman. Two cases.
Jake McNally for the people, Your Honor.
Good morning, Your Honor. I'm with on behalf of Mr. Bashir. Your name, please.
Your name, sir?
Abdurrahman Bashir.
Arrest. Ask the court to please set these for exam. Discovery is complete.
Would the people have their witnesses available? We're on the 5th, correct? Would you have their witnesses available the 5th?
Go one additional week. These are rather old cases, and given the length of time that's passed since then, I likely will need to see a new officer charged for these matters. I just have to show you.
Is there going to be any objection to that?
Yes, and I would just leave it to the court and note the cases are old.
All right. You good? All right. We're tough around here. Anna tripped you. No, I think so too. I'm going to file charges. All right. You want, is he in custody on anything else? And the people want the additional time because of the age of the case. Got to get new.
That's correct. One's 7 years old, one's 6 years old. Reason that they are so old.
Noting the objection, but also noting that the defendant, that the reason that people have to do what they are doing is because of the defendant's failure to appear. I will give that additional week. I will set these for preliminary examination, discovery being complete. I'll set it for May 12th, 2026, 9 a.m. on both cases. All right, bond will continue.
Which judge is that?
Oh, before Judge, I'm sorry. Before Judge Washington. Thank you. Court does call the case, People versus Darius Cadell.
Your Honor, Raymond Cook for the people.
Yeah, ready, Your Honor. Good morning to you. Good to see you, Matthew Mansour, on behalf of Mr. Cadell, who's approaching. To my right. Mr. Cadell, could you please state your name for judge since Judge Cadell? Your Honor, I have two things for you. I have a green sheet and a bond filing. For,
yeah, you can get that up to me at some point.
okay, thank you.
Thank you. You're asking for an adjournment?
Yes, please, Your Honor. I'm going to start the negotiation process. I just got the discovery, the media discovery yesterday, so it's about done.
Why hasn't he gone over to community correction?
Your Honor, I've talked to him about that, and him and his mother. He's had transportation issues. That is not going to happen anymore. He understands. I know that because I let him know how serious these matters are, that this court is not one to play around with. And he knows that he could potentially be incarcerated for not drug and alcohol testing. Something like this, it can be fixed, and it will be fixed. If you just allow, he will test today. Your Honor.
Gonna test clean for everything?
Yeah, yes, sir. Even marijuana. Your Honor. Oh, 1 second, Your Honor, please.
Well, the last year game was Washington. Last time I did it was Washington Saturday.
Your Honor, to be candid with you, to be
Really?
honest with you, of course.
So what changed that?
Just, you know,
Oh, go ahead. I'm listening.
you got to be honest and upfront with you, Your Honor.
Really?
I know how it is. Yes, yeah.
Oh, that's the problem.
Marijuana traces might appear, but he knows
Marijuana traces might appear. What's that mean?
he used marijuana a few weeks ago. I don't know if it's in there or not, but just letting you know, just being honest with you. And he knows
So he got out of jail. He's not supposed to be using any drugs. Does he have a medical marijuana card?
no, but he will not use anymore. I didn't use it like the day before. It was before, Your Honor.
Pardon?
It was before. He used marijuana before he got arrested. I didn't use it after him. And we can track the level. He's going to comply. I know he will.
I don't know that you can make that representation that you know that he will, because he's not thus far.
I have faith.
Okay.
Trying to review.
Yes.
Okay. All right, record should reflect we had a bench conference in this. I'll just put it this way. There is, well, this might seem minor on this case, defendant is also on, and I'm not going to go into detail, but he's on probationary status at the time of this offense. Part of that probation includes that he should not be using drugs, should not be using anything, shouldn't have been using marijuana at that time. So what I will do is give counsel time to check into that and his potential violation of that probation. I'll adjourn this out 1 week to April 30th, 2026, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Court does call the case People versus Kurt Bushland.
National Office for the People.
They may not be able to bring him out.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Bushline, who approaches from the back. Please state your name, sir.
Bushland.
I have before me a plea form that indicates that the defendant will be pleading to an added count 2 of use of cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There is a sentence agreement to credit for time served and fines and costs. That's the court's full understanding of the agreement.
Correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Right then. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Kurt Bushland.
So it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Okay.
Understand that? Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
Signed an advice of rights form or had one signed on your behalf, is that correct, sir? Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you are indeed guilty?
Yes, sir.
September 22nd, 2026, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Had you used it?
Yes, sir.
Did you know what you were using was cocaine? All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in court rules, that would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir? Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 8th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Clay.
National Office for the People.
Good morning,
And
Your
next-
Honor. Wendy Barnwell, P42505. I believe you may have called Andrea Clay when you heard.
Yes, that is the one I called.
Okay. Yes, thank you, Judge.
She here? Andrea Clay, she is not here, Miss Barnwell. Much like you. No, I'm kidding. Because you won't come see me. It's okay. My feelings aren't hurt. You have any notion of her whereabouts?
Judge, I talked to her godmother this morning, and I had heard from her godmother had responded. Now, let me say this. I had sent her a text before I saw, at 1:00 this morning, I saw that the JA had sent me an email saying that she has to be here physically. She cannot come on Zoom. When I initially sent a text message, I told her she may come in person. I used the word may, but I also gave her the Zoom number, assuming, because I accepted the case recently and I asked for Zoom. So that has happened. where I did, but then this morning, when I saw it, I sent her the text immediately. Then this morning I called her godmother and she had enough time to get there. I called early in the morning.
Okay.
So I'd ask that we hold off, but it's within your discretion, Judge.
I know. Thank you. Thank you though for letting me know that. Go ahead.
I'm aware that there's a community corrections violation as well. I request bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you, Ms. Barnwell. And at some point, you're going to come back down and actually see us in person, aren't you?
Yes, you know, I had a trial in Ann Arbor that took up a lot of time, and I wasn't taking cases while preparing because it was a big one.
Got it. Okay, well, we'll see you soon.
All right, thank you. Have a good day, everybody.
Court calls the case, People State of Michigan versus Michael Burge.
People, Your Honor. For the Assistant Public Defender representing Mr. Burge, who is coaching. Your Honor, we are requesting an adjournment for ongoing negotiations. You have a green sheet.
Two weeks, please.
Yes, please.
Oh, you just find that. All right, probable cause conference will be adjourned May 7th, 2026, 9 a.m. Bond continue.
Thank you.
Yeah.
Thank you, Mr. Burge.
Court does call the cases of the people versus Edward Eugene Harris.
Under under Michigan Courtroom 8.120 under the supervision of Assistant Judge Attorney Ellington.
Finally, she's letting you do stuff, right? No, it's your last day. She's letting you do something, but now it's your last day. Good job, Zenda. Well, it's been a pleasure having you before the court. I will say that. And permission to practice is granted.
Good morning, Your Honor. Jonathan Sachs for Mr. Harris in his case ending in 1250.
For show feaster on the remaining cases, Your Honor.
That's right. Is he present?
Got Zoom there, Judge.
Yes, Your Honor. He is.
Mr. Harris, can you state your name, please?
Edward Harris.
What do we do?
Your Honor, we're continuing negotiations. We're hoping to have a good resolution here that should be able to take up all three of his cases.
Yes, Judge. That's accurate. Would be as point adjournment.
All right.
We request 3 weeks.
Hearing no objection, I'll set it. I got it. Thank you, though, for putting your nose in it. We adjourned to May 14th, 2026, 9 a.m. God continue.
Judge.
Thank you, Your Honor. Mr. Harris.
Court does call the case People versus Deanne Bird.
Then we have the people.
Hello.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Burge.
Hello, Mr. Morning, your name? John Bird. Thank you. What are we doing?
You know, I did reach out to Ms. Zinda because we did not receive discovery in this matter. I have spoken with Mr. Bird, who states this is a reauthorization case. So I did, both are. So I did go back to look through our file and I cannot confirm for one of the cases that we did represent them. I believe it's my understanding from him that we did, but in terms of looking through the file and matching the dates that these have alleged to have occurred. So that's the first thing. Please.
Just so I'm clear, what you're telling me is that you may not have discovery because you had a bit of your record on one of these.
Your Honor, I'll make this easier. It was resent for both files. What was I didn't realize it was the same in evidence items. We see a new meeting notice that should be released yesterday.
Got it. Okay.
Still not in my file as of last night when we met. I will check again. I have not checked this morning. So I am asking for some time for that, but I would also like to address bond. And if I could have one moment.
So if you're gonna get the discovery, here's what I want to also make sure of. I don't mind adjourning it out, doing that, but I want to make sure if Mr. Bird's indicating that on the previous ones, that the public defender represented, that there's not going to be an issue. What I would like not to run into, if we can avoid it, is all of a sudden you're here on both cases, but now you have a conflict, and then it's put out, and then
yes,
it's further delayed.
But
we don't know that. Yeah.
I do not believe that we have a conflict just based on my review of our representation of him in the past.
Got it.
And that it's the same complainant.
Okay.
Currently, or pardon me, we very recently represented him on a probation violation involving the same person as that.
Okay. Then I'll adjourn this out to May 7th.
Yeah. I was going to say, could we have a shorter period of time? And I will explain that in part. Even
go ahead.
Even just a week would be fine. That is because Mr. Bird is the complainant in a matter involving this same complaining witness. This is a 2024 case. There's currently a matter where he is the victim, and this morning I was able to find that case and make copies of the register of actions for both Your Honor and the prosecutor. And he has been attending all of those court dates, but there is a concern that part of this case was dismissed in 2024. And I was able to confirm, as my client told me, that just before the meeting with the friend of the court in their divorce /custody proceeding, that the complainant came to the Washington County Prosecutor's Office almost 2 years later, asking to have the matter reauthorized. As it states in the report, that does not mean it's not any less serious, but it is an interesting state of affairs. And he has a pretrial on the matter where he's the victim. He's been attending each of the case, all of the hearings.
That case?
That is in Wayne County, and that is on May 8th. And as I said, I was able to print that out for Your Honor and the prosecutor this morning when I found that.
And I want to say for the record, I spoke with the victim myself before reauthorizing this case, and she indicated to us that at the time these cases were dismissed, she was extremely terrified with the defendant and was not comfortable proceeding. She now has a better support system around her, and he had continued to harass her in the time since these cases were dismissed, and now she felt more comfortable and safe proceeding, and that is why these cases are now back before the court.
I also have, and I did not, because I'm not trying to retry the custody case, but I do have the recommendation where she speaks about what a great father he is and all of those things. So I wanted to
That's several made.
You
right?
Can be.
That's it. So I don't know what that has to do with it.
But
I'm not a family court, so I don't know what that means.
But my point being is that I'm only trying to address these as far as bond and to have a court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly.
Thank
you.
Yes, yeah.
So that's set for the A?
That is set for the A. So if we can have a 1 week adjournment.
Yeah. Any objection to it?
No, Your Honor, the discovery was sent yesterday, so we should have everything.
We'll adjourn it 1 week out to the 30th.
And Your Honor, we would ask that the court, considering how old this case is, and that in terms of since that case was dismissed in 2024, there have not been any allegations or cases as far as Mr. Byrd. The only cases have been I believe there are two, but definitely this one pending, where Mr. Byrd is allegedly the victim. And so with that, I believe that he can abide by any orders, no contact orders, or whatever the court would say would be appropriate, so that he can continue to not only pursue this case, but also his rights as related to being a victim in the other case. And so we're asking for personal recognizance.
I'm going to object. This is two cases of aggravated stalking. In these cases, it includes threats to the victim that include the defendant texting her, "If I see you in EST, I'm walking you, bitch. Don't be home. You need to learn to keep my name out of your mouth." That he will, everyone in the victim's car with her will get hit. And then this case came back to us with the victim because she informed us, and this was in a Washington measures report that it's going to be edited with a related report, in which he was still continuing to harass her, showing up to her unit unannounced and calling her, looking at her social media posts. And that is why this case is dead. So I do have concerns first, given that even when the were dismissed, that pattern of harassment did continue. And I have concerns for her safety.
There's no allegations of any of those things since 2024. These are allegations from that case from 2024. We have not had any case come forth. Pardon me?
That's not what I'm hearing.
December of 2025, that was in a different case that I somehow didn't get added onto this one as a related report. That includes allegations of him coming to her unit in 2025, December of 2025. We continue to harass her. So I will add that and get that citizen today.
Donna, that was after those other matters were dismissed, and there continue to be parents together. But if the court implements an order, a no contact order, then he will abide by that order.
Since I'm adjourning it out the 1 week, 30th, I'll just adjourn it out there. At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that other report, see whether or not that other report is relevant to your bond argument.
Thank you.
Thank you. Court calls the case, People versus Jeremy Shue.
As false for the people.
Good morning, Your Honor. Jonathan Sachs for Mr. Shue.
That's the one.
I believe he is on Zoom.
Have it. Oh, he's the scales of justice. Mr. Shue, really? Okay. Jeremy. I'll pass it. We'll see if he'll show up.
Thanks, Your Honor. I'll get in touch with him right away.
Court does call the case, People versus Antonio Guyton. Oh, they're not up yet. Sort of pass that matter briefly. Let me.
Yeah.
Court does call the case of the People versus Antoine Thomas.
That's false.
Albert for Mr. Thomas, who should be logging in Zoom. I know he's having some trouble earlier. Yeah, Judge, can we pass the matter? I know he's been trying to log in, but I guess he was having some trouble.
I'm here. I'm just trying to figure out how to turn on camera. Can you hear me now?
I can hear you. Can't see you.
Okay, let me see.
Oh, that's Jeremy.
It says Antoine Thomas was.
That wasn't Mr. Shue. I see Mr. Shue on the screen. That wasn't Mr. Shue. That was Mr. Thomas.
Can you guys see me now?
We can see you.
And Antoine, if you could please state your name for the record.
Antoine Thomas.
Your Honor, Your Honor should be in possession of.
I have a plea sheet in front of me that defendant is going to be pleading guilty of a controlled substance, a 1-year offense. On his successful plea to that charge, count 1 would be dismissed. I also have a sentencing agreement between the parties. Prosecutors deferred sentencing. That's the court's full understanding of the agreement.
That's correct, Your Honor. Thank you.
Yes, Judge, that's correct.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Antoine Thomas.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of, which drug are we talking about? Cocaine?
Yes.
Yes.
Okay. That's a misdemeanor, punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would sentence before Judge Garwood in the 15th District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all the rights, particularly the rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you're guilty of this offense?
Yes.
September 15, 2025, at the location of Boardwalk Drive, City of Ann Arbor, Washington County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, I have.
And did you know what you were using was cocaine?
I was aware. Yes.
Okay. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely. Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I am not.
And have I complied with the court rule?
People are satisfied.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
May 12th at 9 a.m.
May 12, 2026, 9 a.m. before Judge Garwood. Bond will continue.
Thank you, Judge. We'll be in touch, Antoine.
Okay. Thank you, Kyle. Have a good day.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Antonio Guyton.
Again, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Guyton. Your Honor, this morning, Mr. Guyton will waiving the preliminary examination. We've submitted a preliminary examination form waiver.
So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with counts 2, 3, and 4. Follow.
What is good? I'm so sorry, what was that?
What are counts 2, 3, and 4?
Those are misdemeanors. Okay. Joy, pardon me. Your Honor, we acknowledge receipt of the information, waive its reading on the record, and at this time, my client wishes to stand mute and have the court enter a not guilty plea in his behalf.
Defendant having waived all reading, standing mute, court will enter a not guilty plea as to all 4 counts. Pre-trial will be set for
May 4th at 1:30 with Judge Hamoud.
May 4, 2026, 1:30 before Judge Hamoud. Bond will continue.
Your Honor, we have also submitted
I signed it.
letter. Thank you so much. So he signed the order regarding treatment.
Thank you.
Thank you.
They need to stay. Court recalls case People versus Jeremy Shue.
That's thoughts for the people.
Thank you, Your Honor. Jonathan Sachs for Mr. Shue.
Jeremy Shue.
Now,
Thank
As
you,
soon as
Jeremy.
you called my case last time, it kicked me out of the Zoom hearing, Your Honor. I'm sorry.
It did?
Yes, it did.
I probably did that on purpose. I'm kidding.
At this point, I wouldn't be surprised, but not
And listen to you. Don't even try it, Jeremy. All right. What are we doing?
thanks, Your Honor. This had been adjourned a number of times for Mr. Shue's Court of Appeals pro per motion. That has since been denied. So I'm requesting an adjournment for us to talk about a potential resolution of this case, and then we would combine a misdemeanor case in Judge Wash's courtroom if that comes together.
I don't know what the last part of that meant. How much time did you need?
Could we get that same May 14th date if possible?
Jeremy, I'm going to adjourn your case May 14th, 2026, 9 a.m.
Yes, sir.
All right. All right. Bond will continue. Take care.
Thank you, Judge.
All right, have a good day, sir.
Here. Court calls case People versus Jada Olive.
People. Good morning, Your Honor. Robert Ellman on behalf of Miss Olive in case number ending in 1321. Your Honor, Mr. Kolovos was here. He is representing Miss Olive on the other case. However, I was informed this morning that he is taking over my case as well. I believe he filed an appearance. He has asked me to stand in on these matters.
Well, he'd have to file a substitution, first of all.
I understand, Your Honor. I'm working with what I have here.
It's pretty much the call of my given day or any day for me.
So,
all right. So you're looking for an adjournment.
I know that I had Mr. Kolovos fill out a couple of green sheets. I believe you have those in both files.
Should have the green sheets.
Yeah.
Mr. Cole was here.
Where'd he go?
He indicated. I told him if he
He had to go someplace else. The judge would be upset if he didn't go there.
correct.
So what am I supposed to do?
Apparently not
I'm-
upset.
I'm kind of inconsiderate judge.
Your Honor, on behalf
I have to change that whole.
on behalf of Miss Olive, I'm here and I'm happy to see.
No, I'm not. Miss Olive is. You understand? What's his name? Clovis.
Kolovos.
He's going to be representing you on the both matters. Is that your understanding? All right. Do you have any, for the purposes of an adjournment today, do you have any objection to Mr. Almond stepping in?
No, sir.
All right. Thank you. All right. Did he indicate to you as he headed off to the other judge that he likes more? How much time he'd need?
No, Your Honor. I believe maybe sometime in an early May date, maybe mid-May would be fine. I don't know. Your Honor, I spoke with Mr. Kolovos this morning, so I don't want to put words in my mouth. I think that we're getting pretty close to a waiver being included here between the city. Sorry.
Are these the only cases holding you, young lady?
Yes, sir.
Are still being
That,
let me double check, and I believe she has
I'm done.
probationary matter.
oh, she's serving time on probation violation. All right. Then I'll adjourn it to May 7th.
Thank you, Your Honor.
Both matters. 26, 9 a.m. All right.
Thank you, Your Honor. That's it for me. Have a good day. That's it.
Here, nothing. No, I'm kidding.
I could have left with Mr. Kolovos, Your Honor.
Yeah, I got a way of getting you back.
It's good.
But anyway, never mind. All right. Thank you. Have a good day. Court does call the case of the People versus Sebastian Phillips.
For the people, Your Honor.
Good morning, Rob J. Columbia. Name Sebastian. Judge, I know my client is anxious to get this case going. However, we still don't have the report from, pardon? We don't have the competency report yet, Your Honor.
We do, I have a copy of it, CFP. We got the competency report. He's talking about, I guess.
In this case, I don't have it.
We have an ATO with, Darlene O'Brien that he's saying that we could use for competency, referral to go to, Kalamazoo Psychiatric Hospital until I'm being competent. That's what he was trying to indicate, but.
Judge, can we adjourn this out a couple weeks?
Can I make a statement?
And I don't have one.
I have it right here. I have a copy of it.
From the forensics?
Yeah, from the forensics. It's Judge Simpson.
Is that the report that says you're incompetent?
Yeah. Are you not referring to that?
We're waiting for you to gain competency. We know what we know about.
No, the incompetency report.
Yeah.
The other report or a review of that report, correct?
Correct.
Yes.
And that report, Mr. Phillips, you don't have.
I thought, see, he's not being clear and concise with me. My attorney.
Oh, Mr. Kilowatt is one of the most.
I know he's good. I'm just saying that we're having some clear issues with being clear and concise on the specific.
Well, let me be clear and concise. There was a report that found you incompetent.
Right.
I do not have any other follow-up report. Mr. Kennedy has indicated the people do not, and Mr. Kilowatt has indicated he does not.
Okay.
Follow-up report.
Okay,
So all I can do is adjourn the matter. So we can get a follow-up report.
So are you referring to a referral to a CFP facility? Is that where you're?
I'm not referring to anything. The only thing I'm referring to is I don't have a report.
Yeah. So what I'm trying to understand, because I don't understand, is if we have the CFP report, then need an additional document. Is what you're saying? In order for me to be
Mr. Phillips, the report says you're incompetent right now, but restorable. Right. We're waiting for that. You and I discussed on the matter and the other matter, if you want to go to the psychiatric hospital in Kalamazoo, that if you think that'll help restore you, that we shouldn't confuse the two cases. In this case, Judge Simpson does not have a report that says you're competent. I'm asking you to adjourn this out 30 days.
Yeah. So what I wanted to say is that they, oh my God. Would it be IST? Incompetency in trial? Would that be an order that needs to be? Because we're trying to figure out if I'm deemed incompetent, where am I going to be? Because they said that they can't. Community mental health said that they can't.
You have to work that through with your attorney. The order finding you incompetent, that has already happened.
Yeah.
I'm just looking for a review of that.
Oh, sorry.
Mr. Phillips, let's just get the 30-day adjournment. If the judge will grant that, I will deal with the other matters, see if we can get a referral order.
I will adjourn the competence hearing to May 20th.
I'm sorry, Judge, what was that?
28th, 2026, 9 a.m. Defendant's bond will hit.
Thank you, Judge.
Yeah.
I'm going to explain it.
Oh,
you call it.
Court calls the case People versus Joshua Hillsberg.
People, Your Honor.
Robert, on behalf of Mr. Hillsberg, who is coming out to join us as we speak.
And her name?
Joshua Hillsberg.
All right, what are we doing?
Thank you, Judge. Your Honor, Mr. Hillsberg is being arraigned on an additional charge this afternoon. So we are asking for an adjournment so they can catch up.
when we give a date that they're gonna try to set his other cases. We were gonna give them a date. So how much time did you want? You want 2 weeks out or 3?
There is, in relation to that, there's some additional media I'm expecting, along with some supplement reports.
So we got this one.
So it may.
It's very simple. Yeah, I mean,
2 or 3 to work.
I'd ask for the shortest side.
Well, I also want to make sure that you're gonna get the additional media, because otherwise we're gonna get here and then we're gonna ask for an adjournment. But if you want the shortest time, I'll give it to you. First time, May 7th. Hope we have everything. May 7th, 2026, 9 AM, bond continued.
Thank you, Judge.
Thank you.
Okay.
Court calls case People versus Going Robinson.
Good morning, Your Honor. Assistant Public Defender, Janadra Ikariakanlili, on behalf of Mr. Glenn Robinson on the 1556 now.
Morning, Honor. Rob J. Cole. Judge, I have case 2330.
Your name, sir?
Owen Robinson.
Thank you, sir.
Judge, I met with Ms.
Great to see you, Ms. Eckerman. I was at a conference and somebody asked specifically about you and how you were doing.
Oh. I
gave them my report.
That's good. Great things, Judge.
Okay.
Judge,
what are we doing?
Mr. Robertson and I met in my office. At this point, he wants to set it for exam.
And on your matter?
The same, Your Honor. We'd like to set it to preliminary exam.
All right. Discovery is all complete on both cases?
Yes, Your Honor.
Yes.
Would the people have their witnesses available the 5th? Preliminary examination in this matter in both cases, will be set for May 5th, 2026, 9 AM before Judge Freshour at 10 AM on the 5th.
10 a.m. Okay. Thank you, Your Honor.
Thank you, Judge.
I'll talk to you beforehand, okay? Be good.
Court does call the cases of the people versus Chidra.
Your Honor, reading. Assistant Public Defender J. Ballon John, on behalf of KJ on all matters not ending in 1678, Your Honor.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on his other matter. And he is coming from.
He's actually right behind you.
Oh.
Right behind. Oh, so thank you. All right. Waiving.
Your Honor, yes, he is waiving, and we have an agreement to be placed on the record. And after his waiver of the prelim, we'd like to address bond, please.
And Your Honor, that's accurate. It's a bit of a long agreement, but I guess with council's permission, I'll go to the brief version. He's going to be waiving off on the 3 non-CSC cases. He'll be pleading to misdemeanors under HIDA in circuit court, with the idea being to keep the probation all in one place. Misdemeanors on those cases. I'll leave Mr. Fenton to outline the plea of the CSC matter. Yeah, someone else with that matter, Your Honor. Bond over 64 to 1360.
Got a correct statement.
It is, Your Honor.
It is, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand all of these matters. You understand that a preliminary examination is where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand.
You understand that in all of these cases, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
The people on all of these matters also waive their right to preliminary examination.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on 1, 2, 3. One, 2, 4. Just trying to make sure I have all of the counts. On all 8 felonies, he's waiving and followed by the one misdemeanor.
Correct, Your Honor. As to that, we would waive formal reading, stand mute, acknowledge receipt of the information.
Us to Your Honor on case number 1678.
Good, and having waived formal reading, standing mute. On all of the cases, court will enter not guilty plea as to all charges. Pretrial in these matters will be set for
May 12th at 1:30 with Judge Conkey.
May 12, 2026, 1:30 for Judge Conkey. Esteban.
Thank you, Your Honor. Mr. Ikeji has been in, he's now approaching 200 days. The original bond that placed him in jail became reasonable based on mental health issues that culminated in a new arrest upon the same day as an initial release. That obviously was a unfortunate set of circumstances that resulted in a series of mental health evaluations, new treatments, competency and not guilty, but and insanity evaluations. The result of that now is he's been on new medication for a number of months now. Mr. Bellamy and I have both seen he's basically a different person since that started up. The forensic center noted the same thing on their evaluation that recommended or that concluded not guilty by reason of insanity. We have confidence now that with home confinement, he's going to do really well. His father is here today. He would stay with his father. His mother could not be here today because of work, but she has been at every other court proceeding. Mr. Ikeji has graduated from New York University. He has no criminal record beyond this series of arrests that were all part of the same connected mental health crisis. He's an extraordinarily promising young man. I look forward to his success down the road. And we're simply asking that close to 200 days is more time of incarceration than he is absolutely going to receive once these pleas are implemented. So we would ask that you consider a shift to home confinement today.
Response from the people.
Your Honor, people are fine. By fidelity, also after the defendant, that condition of the defendant's not apply with any worse for CNH as well as in prescribing drugs or medication.
Any other response from the people?
No, Your Honor. No, I would just echo what Mr.
So you have no objection to a PR home confinement in compliance with CMH?
Correct.
All right, I don't have a problem ordering that then if everybody's in agreement. However, I'm going to need an order to that effect.
We'll get that for you, Your Honor.
And it's a home confinement tether, correct?
Yes.
All right. Well, I'll need the order because these files will otherwise be going up and then it'd have to be signed to somebody else, but.
We'll get that to you today, Your Honor.
Okay, thank you.
Thank you, Judge.
So we'll keep your date. Thanks, Michelle. Okay.
Thank you, Your Honor. Stop being like that.
You're gonna have to. Right, you're gonna also have to, something with this bond order, they're gonna need to prepare an order for me if they're gonna. They need to know that, but I wanted to make sure all this paperwork. And then I don't have. Counsel on these, will prepare them for your signature of the information. However, I do not have all of the, I only have 2 of the information. So you have to check with my staff to figure out which ones you need to print and get to us.
Yeah, understood. Thank you.
Well,
Thank you.
Yes.
No, good chance.
I'm gonna have this bond continued because
Absolutely.
otherwise,
Till the form comes.
yeah, I've got 2 of the information. Court does call the case People versus Diamond White.
People, Your Honor.
Morning, I'm Rob Jacob on behalf of Diamond White. Your Honor. Diamond White.
Thank you.
I'm sorry, I have a green sheet. When we adjourn this a couple weeks, who's appointed?
On the other side of this.
Pardon me?
And then I have a few more stuff.
Thank you. I didn't hear, so. All right, you want to do what?
I was just appointed if we could adjourn this a couple weeks.
Have a green sheet?
Yes.
How much time did you need?
Couple weeks.
Public cause conference will be adjourned May 7, 2026, 9 a.m. Bond.
We got this in.
Thank you.
Sorry, what? Yeah. Yeah. All right, thanks, Judge.
Court calls case people versus Santos Alatif.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Alatif. Mr. Alatif.
Sir, Alatif. Thank you.
Your Honor, we are asking that this matter be set for preliminary examination. We'd also like to address a bond request.
I have a bond request.
Your Judge.
He's out.
Yes, we'd like to keep
Okay,
that one.
messed this up, aren't you?
No,
Wait, you have all discovery?
to our knowledge, Judge, yes.
People have their witnesses available the 5th?
Try for that date, Your Honor.
Oh, that's, okay. Preliminary examination will be set May 5th, 2026, 9 a.m. That is before Judge
Perry.
Perry. Yes, that's the bond.
As to bond, Judge, Mr. Alatif indicates that he has a wedding that is scheduled for June the 24th
Not his.
Not his wedding, Judge, no.
Nobody needs to be there.
Nobody needs to be there.
It's gonna happen.
Mexico.
Go ahead.
It's in Cancun, Mexico. And yeah.
Go ahead.
So we're asking for permission to allow him to travel for that time period to the
What's the time period?
June the 24th to return on the 30th.
It's a long wedding.
I know, Judge.
Any objection from the people, please? Really? No.
Request just test and get it down.
I will allow the defendant to travel to Cancun. Those include your travel dates, sir?
Yes, sir.
June 24th to June 30th. You can travel to Mexico.
Thank you.
I would indicate that immediately upon your return, June 30th is the meeting. So you are to report to July 1st, 9 a.m. to Community Corrections for take needs. Okay.
All right. No.
All right. Thank you.
Full panel with an ECG.
Yes, full panel with it.
Okay.
Yeah. We'll prepare that one.
Thank you so much, Judge.
Thank you. Court does call the case, People versus Kelly, Joe, well.
Good morning, Your Honor. Edward Jerkis on behalf of the defendant.
Oh, good morning, Mr. Jervis. All right.
Good morning.
Your name?
Kelly Group.
All right. You're asking for an adjournment, sir?
Yep, for the purpose that's stated on the green sheet.
All right. 2 weeks. Will 2 weeks do for you? Or
2 weeks can work. I have this submission form for the recovery court I was going to turn in, but it may take a little longer than 2 weeks.
longer than that? Yeah. Okay. Why don't I do the 14th? Let's see where we are. Okay.
Sounds good. Thank you, Your Honor.
All right, I'll adjourn to May 14th, ma'am. All right, 9 a.m. Bond continued. Thank you. Court calls case, People versus Jennifer Baker.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who appears via Zoom. Ms. Baker, can you please unmute yourself and state your name for the record, please?
Yes, Jennifer Lynn Baker.
Your Honor, I'm just taking a little more time. We're in the middle of negotiations on this.
7th work or the 14th?
7th is just fine.
Adjourn the matter to May 7th.
Thank you.
2026, 9 a.m.
Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Court calls case, People versus Connor Kearns.
Then on behalf of people, Your Honor.
Morning, Your Honor. Richard Lippin on behalf of the defendant, Mr. Kearns, who's approaching the podium. Your Honor, in regards to the probable cause conference, I spoke with the prosecutor. I believe that we're going to try and resolve this matter by seeing if Mr. Kearns would qualify to get into Veterans Court. He needs to be screened at before it happened. For that reason, I'm asking that we have a new PC for May 21st.
21st, okay, that'll be fine. Probable cause conference, I'll adjourn to May 21st, 2026.
Thank you, Your Honor. Now, on a separate matter, Your Honor, I'd like to make an oral motion regarding bond.
No, go ahead.
Your Honor, the court is well versed in this case, having spent an inordinate amount of time on it earlier this week. Mr. Kearns is the first time this is his first criminal matter of any sort in his life. He's 31 years old. This has been a sobering experience for him the last 72 hours. I think that he has a greater understanding of the seriousness of the orders of this court. We're asking that the court consider releasing him at this time to home confinement, work, school, court, those types of things. If the court is inclined to give him home confinement, we would also ask that he be allowed to go to the YMCA. He tells me that the victim is not a member of the YMCA, does not belong to that YMCA. And so that would be our prayer, Your Honor.
In Ann Arbor?
Which YMCA? I think in Dexter.
In Dexter?
In Dexter.
Dexter. Response from the people.
I would not have been released on a home confinement with other hours for work and school. Yeah.
All right. What I will do is I will grant defendant's request. I'll reinstate his previous bond amount. He will be released. He will have to report. Actually, I want a GPS on him prior to his release. That would be a home confinement. GPS tether with releases to school and work only, and the YMCA only.
Is that an order that I need to prepare, Your Honor?
We will prepare. I have the order reinstating his previous
Great.
To the community corrections order. We'll prepare that.
Great. So I don't need to upload any.
No.
Great.
You got it.
And then, Your Honor, if I could just quickly voir dire the defendant for one quick second. What happens if the victim shows up at your house? What do you do?
I call the police.
Okay. What do you do if you see her anywhere?
Call the police.
Okay. You don't speak to her. You don't do anything. You understand?
I understand.
Okay.
You understand, sir, because of what was in this, that includes texting or any communication of any type.
Yes, Your Honor. I understand.
You understand that through no electronic means whatsoever, meaning the use of the internet or anything like that. Are you to refer to her in any way? You understand that?
Yes, Your Honor.
And you are not to try to communicate with her in any way. So understand that.
Yes, Your Honor.
You understand that that also applies to your family members
Yes, Your Honor.
and that you would be directing them not to do that.
Yes, Your Honor.
And that if court were to find that there was that type of third party communication, you would explain to them that your liberty is in jeopardy. You understand that, sir?
Yes, Your Honor.
All right. Very good.
Thank you very much, Your Honor. Thank you for your time on this matter.
No problem. Thank you, counsel.
Thank you very much.
And counsel on, did he leave already? He bolted. Can you just check, and I need counsel to approach on that last one. Went into a side room.
Looking from me.
Court does call the case People versus Maurice Boyd.
Have about this for the people.
Assistant Public Defender, Tanasa Perry, I move Your Honor on behalf of Mr. Maurice Boyd, who's been on Zoom, Judge.
I'm walking to the. Okay. Mr. Boyd, can you stay, please?
Maurice Deshaun Boyd.
Thank you, sir.
You're welcome.
Judge, we're asking for an adjournment to put together some mitigation for Mr.
No, fifth matter. 14, 2026.
Thank you, Judge.
Thank you. God bless.
And to you, sir. Court does call the case People versus Jason Haidu Banks.
Then we have.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Haidu Banks, who's up
Really?
in the podium.
You were there all morning.
I know it's about time.
There's something cutting up.
I know.
Oh. She won't give you a lot?
Your Honor, I have quite a few cases actually. It's just they're all at the end, toward the end of the alphabet of your block.
Got it. Okay, understood. Your name, sir?
Jason Oscar Haidu Banks.
Thank you.
Your Honor, we're requesting about a 2-week adjournment. Mr. Haidu Banks has informed me that him and his family are working on retaining Allison Krieger, and she just needs a few weeks to get that ironed out, and hopefully she'll be prepared to proceed by the next.
2 weeks, you think?
I believe that should be enough.
Yeah, 10 days or 2 weeks should be good enough, sir.
Okay.
Yes, Your Honor.
So I will adjourn it out to May 7th, 2026, 9 a.m. That's the only adjournment you'll get for that purpose, sir.
Thank you, Your Honor. Much appreciated.
All right.
Your Honor.
Okay. Court does call the case People versus Glenn Bradford.
And Assistant Public Defender Jay Longer on behalf of Ms. Bradford, who approaches with Glenn Bradford.
Do I have before me a plea sheet that indicates that the defendant would be pleading to count 2 of violence. Upon a successful plea to that charge, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement to sentence under 7694A.
That's my understanding as well, Your Honor.
All right, very good. Let's have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, but the truth so help you God.
Yes, I do.
State your name.
Glenn Bradford. Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Yes, sir. All right. Understand also, sir, that while in take, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B. Still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Your Honor.
Question regarding any of those rights?
None.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today to get you to plead? No. Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're indeed guilty of this offense, sir?
Your Honor.
On date of August 7th, 2025, at the location of 1043 East Forest Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Gabriella Bradford that makes you think that you're guilty?
Gabrielle.
Gabriella
would be my daughter.
Your daughter. Okay.
Me and my wife had an argument and I shoved her.
Okay. What's your wife's name?
Gabrielle Bradford.
Gabrielle Bradford. Okay.
The E at the end.
Got it. I see it. All right. And you shoved her. You did that on purpose, sir?
Yes.
You didn't have her permission to do that?
I didn't. No, Your Honor.
And as you've been, it's your spouse. Sir, if I accept your plea, but you commit misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea. You understand that, sir?
Your Honor.
And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be June 1st, 2026, 10 a.m. before Judge Washington.
So
bond with its conditions will continue.
as soon as possible. I just
See, I told you.
we'll get it. Do it, Judge Washington. Okay. Right.
Okay.
So that, call me if you have any questions.
Do it. Just you just need to have more faith in people.
That's Judy bit.
Oh, well, maybe not. No, June 1st. Court calls the case, People versus Matthew King.
People.
Yeah. It's just never gonna end.
Good morning. Joy Gaines, your Assistant Public representing Mr. King, who's present to my right. Would you please state your name, sir?
It's totally okay. How you doing, Mr. Suffolk?
I'm doing great, Mr. King. How are you? Good. All right. What are we doing?
Your Honor, we did not have discovery yet as of yesterday when I met with Mr. King. Miss Sunda, I'm assuming because I emailed her at the same time regarding his as the other clients that we will have it. Regardless, Mr. King wants to schedule the preliminary examination. And he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. Further, there's going to be more discovery because I was planning to address bond today. So there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are a few things in play here that I do not have yet and that defense does not have yet that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go.
That's fine.
Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss
Okay.
King, let me just explain to you though, the problem's gonna be you may be in there longer, sad, and nobody can go because they don't have the stuff and your counsel can't even advise you as to what you need to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was gonna say, I know that you and I talked about that and you understand that. And you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay.
Everybody lying.
Here's what I'm gonna do. That the discovery that you have now, you can get over to,
It was sent yesterday, Your Honor.
it was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further subs along with that surveillance video from where the actual assault occurred. And then, potentially, and then the schemes would also get the jail calls, that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm gonna do something with the date because everybody seems to be in a hurry. So I'm gonna set an in-person preliminary examination. I'm gonna set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Thank you.
As the bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family, that his sisters, I believe his mother, in these calls, he says, my son don't need to come to court, man. You don't need to come. Talk to his mama. Talk to his mama. You're right there. If you want to help your nephew, you need to get on that phone and talk to his mama. That's what I said. It's going to kill him in the end. She's supposed to be on it. I don't know what I would do. And further things telling them they need to talk to the victim's mother. The victim is his minor son. So he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering case as well.
Okay.
You know, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother and his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well,
I cannot have only direct contact, Ms. James. As you know, he can't have indirect contact.
Correct. I'm not disagreeing with that. I'm just saying that based on our in terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right, what I will do, so I'm gonna read the people's request. The defendant's phone privileges and texting privilege are hereby ordered revoked. Hold on, sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr. Sir. I haven't did anything wrong.
Want a hearing on it? Because I'll have to listen.
Let's do a hearing today, because I need to talk to my family. I have things going.
Sir,
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted none of them.
Bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't. Sir.
Are you going to listen to me? Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can take your head all you want. I'm just going to leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm not going to do it. Yeah, we're gone. We're done. Court calls the case. People versus Danita Combs.
If you're on that?
Yeah.
That's also for people.
And where we are, on behalf of the needed calls.
Yeah, it's me.
Hello, what's your name?
Danita Combs.
Okay. What are we doing?
Yes, we do have a
Deck of cards. Go ahead.
judge. We're asking for an adjournment. We're trying to establish contact with Ms. Combs so that we can review the report with her, Judge.
Probable cause conference will be adjourned then to May 7th. Ms. Combs?
Yes.
You need to contact the public defender's office. You have their number?
I believe it's 222. Hold on. I think I just dialed it.
222-6970.
Yeah, I called them today, and I
called
talked to them yesterday.
Just listen. You need to call them, make sure they have a good phone number and email address for you so that they can contact you and go through what's the matter with you, okay?
Okay.
All right. I'm adjourning your matter out a couple of weeks to the 7th, 9 a.m.
Okay.
Okay?
Okay, thank you.
Thank you, Judge.
Bond will continue. Thank you. Court calls case People versus Kenneth Mays.
For the people.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Mays.
Morning. Good morning. What's your name, sir?
Kenneth May.
Thank you. What's he doing?
I don't know.
Tell him to stop. It was better when he was in that little box.
Aww.
I know. That's so true. All right. What are we doing on this?
So first of all, Your Honor, this matter was adjourned to today so that Mr. Mays could determine if wanted to have a hearing on the bond violation or if he or did not want to have a hearing. At this time, he is not asking for a hearing. He's asking that the court find his admissions to having used be sufficient, and is also asking for immediate sentencing to, I believe he has 8 days credit with credit for 8 days served, to 8 days with credit for 8 days served, and that his bond be reinstated. Yes, so he can return to work. He does have a good job at a warehouse at Haggerty, of course. I think that's Canton, but I'm not quite sure.
I'm sorry?
I think it's on, I think Haggerty and Ecorse is Canton, but I'm not sure.
Okay. Your response from the people.
Your Honor, I think the last time we were here, the defendant admitted to that he had used things before he was arrested. I don't recall a specific admission to things while he was on bond. So I just wanted to make sure the record was clear as to that. I think he was saying he wasn't sure how the amphetamines were in his system on April the 16th. So once the admission is on the record, I have no opposition to him getting credit for time served and being placed back up on.
He's admitting to that at this.
Okay, to the use of the amphetamine after the point he was placed on.
That's correct.
Yes, sir. Was this chance thing I wanted everything done. So what I'm going to do. So what are we doing with the case itself?
I set this for comments and input.
Oh, no.
Okay. Your Honor, maybe have an adjournment. I will fill out a green sheet so that we can see if we're going to be able to work something out. Our conversation focused mostly on violations.
Staggered. So I'll adjourn this out, sir, to May 7th, 2026, 9/8. What I will do is I will accept the defendant in the violation. I'll sentence him to 8 days in jail, credit 8 days served. I will indicate that his previous bond is reinstated with all conditions, including testing. So you're going to go back on testing. You understand that?
Yes, sir, I do.
Now we're real clear what happens if it shows up dirty.
Yes, we are.
I'm crystal clear, right? Okay, I got you. Okay.
Okay. All right. Thank you, Your Honor.
Wait a minute. Yes. Oh, where is?
That's all. Larry.
Bellinger
Yes, Your Honor.
and counsel on this one approach. Who's on the other side of your uncle?
That's going to be, Ms. Feltus.
Oh. Now it did. Don't question me when I tell you something. You know what, Alan? Don't say sorry. Court calls case, People versus Enrique Davis.
People.
And good morning, Your Honor. Assistant Public Defender Alexis with and on behalf of Mr. Davis, who should be appearing on Zoom.
Yes, Eric Davis.
Okay, Eric Davis. All right, he's here.
And Your Honor, I do have a green sheet. We're just asking for a brief adjournment to continue some discussions with the prosecution.
May 14th, 2026, 9 a.m. Bond continued.
Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the case People versus Michael Moore.
Morning, Your Honor. Raymond Cook with the People.
All 5 cases.
Yes.
No, you got to be on that side.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Moore. Would you?
Your name, sir? Spencer Moore. Thank you. What are we doing?
Your Honor, Mr. Cook indicated today that there will be new additional charges authorized as to Mr. Moore. So there are more cases coming. And we have been talking about trying to work out a global resolution. So we'd asked for a short adjournment in order to have those cases track. Yes.
Okay.
I see two additional requests in the queue. I'm planning on getting those reviewed tomorrow morning, so shortly here. I did also just want to clarify, I believe that there may have been a stipulated order for release to treatment. Does the court have that? I don't know if that was submitted yet or if that was.
I don't think I have that.
I believe that a stipulated order was submitted by Miss McGee when we were in court last time. But if Your Honor does not have that, I will look into it again. And I will double check. I did work on one with Mr. Childers for the first case that he had.
So it may be one, but not covering all cases.
The only reason I bring that up is I was checking XGL. I do see he has out of county holds. I'm not sure if that's going to affect his release to treatment.
Got it.
Because I see, I believe it's check here, Dieter Warren. There's a hold for another larceny from a motor vehicle there.
Probably going to be a problem because I'd be releasing him on a PR to treat with a tether.
I will have one of our paralegals see if we can resolve that. They've had good success with that in the past.
Yeah.
Yes, they have. I'm really impressed with what they've been able to do.
Your interns?
Well, I'm sure the interns could too, but the paralegals.
Oh, I
don't
like any of your paralegals. Just thought I'd say that out loud. All right.
Let me know.
You're welcome. Other charges that are coming. I want to give a date so we can try to get everything together for this gentleman. If I put it out 2 weeks.
I'm going to try and get them reviewed and either have a decision tomorrow. I don't know how long.
Okay.
Officers come in and swear to the new charges, if any.
Okay. If we can get those done, then get him arraigned on those.
2 weeks should be fine.
Thank you, Ms. Fount. All right. I will adjourn these then to May 7th.
Thank you.
All right. Thank you. Court calls the case. People versus Philip. Petruccio.
Your Honor.
Your name, sir?
Phyllis Patrizio.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. DiPatrizio.
What are we doing?
Your Honor, I do have a green sheet in this matter. We are asking for some additional time for investigation and ongoing discussion with the prosecution. We would also like to address bond.
We'll adjourn the matter to May 14, 2026. All right, Esteban.
Your Honor, Mr. DiPatrizio is on a GPS tether, and we are asking if the court would consider removing the tether. Since he has been on the tether, there have not been any violations. He has not gone to the hotspot. This is his first, it's my understanding, this is his first contact with the criminal justice system. He is asking that have the ability to, in addition to being able to have the tether removed, that he would also.
Who's the alleged victim to him?
I believe it is his former partner, the mother they have a child in common. And he is also asking that they be able to have some contact as with regard to the child in common, no other contact.
there a divorce pending? What's going on?
My understanding is that there was a messy divorce with
It was a what?
a bit of a messy divorce, but that I believe
And after that
finalized.
came out? Yeah.
Yes,
Okay. And so there's messy divorce. These charges come out and you want me to remove the tether.
that is his request, Joe.
All right. Response.
This is the second, count on this, and the first, the aggravated assault, or an aggravated stalking in the past, which was dismissed, and the contract had continued. They previously had, some contact in regards to, however, he violated that, and so that was removed. He would speak about the children, but then also speak about other things. The victim has expressed that she's extreme emotional distress, and that she feels from the type of communications that he with her. So at this time, we the remain as well as the no contact and no go to.
Anything else?
Just for clarification, Mr. DePrizio is saying that he has not had any contact with his former partner, that any contact he has had has been with his daughter. And it's my understanding that in the divorce decree, that there is contact permitted for the purposes of visitation, other like that with regard to his daughter. So that is all, those are the only two modifications he is requesting. He has no prior convictions. Is that right?
Well, you're requesting a modification, take off the tether.
Yes.
Really what you're asking.
Yes. And he spent 3 days in jail on this matter already. So he is very, very sure that is not a place he wants to return.
Given all the circumstances, motion for bond modifications denied. I'm going to leave everything in place. So his bond will continue. We'll see him on the 14th. Thank you.
Yeah.
Thank you. Court calls the case People versus Angeles Warren.
Joy Gaines, Senior Assistant Public Defender. We need help.
Okay, fine. So,
Gaines, Assistant Public Defender, representing Ms. Warren. Your Honor, when we were before the court last time, Ms. Warren was in the Wayne County Jail, and we're not aware of that in time enough for her to
have not signed in. I think there was a writ and everything done. They just haven't.
That is correct. I have no explanation for her whereabouts.
I'll adjourn it to May 7, 2026, 9 a.m.
Thank you.
Some cooperation. Thank you.
Oh, dear.
Propose the case People versus Jaquia Dunlap.
Your Honor, for the people.
But the sports show Easter, defender on behalf of Tepe Dunlap. I've called that man here in the courtroom. Just don't know if they're on Zoom or not, but they do not appear to be in the courtroom.
I'm here. I'm sorry. I'm just trying to get some lighting for you.
You want to do what?
I was just trying to get some lighting, like turn my light on for you.
Okay, you did a good job. What's your name?
Sorry, yeah, thank you.
What's your name, sir?
Jacques Dunlap.
Thank you, Judge.
You're welcome.
Have communicated an offer to, offer to the client, I believe. He is still considering that. We can have a brief 1 or 2 week adjournment. We'll be at matter full.
Double cause conference, May 7, 2026, 9 a.m. Bond continue.
All right, thank you.
Thank you.
Thank you.
Thank you, Judge.
Wake you up. Yeah. Done this? What was he doing? Just sitting there? Sleep?
Tend to walking down.
He was focusing on, oh, I see. Okay. Nice save for him. I don't know why you take his side. Court calls case, people versus Man Davis.
Morning, Your Honor. Assistant Public Defender Alexis Zerb on behalf of Mr. Davis, who is approaching. Mr. Davis, can you please state your name for the record?
I know. What's your name? Name? Man Davis. Thank you.
Your Honor, we were originally expecting to do a waiver today, but Mr. Davis is on the magistrate's docket this afternoon for a new case. So we figured we should hold off for that case to come with these other cases.
Okay.
Ask for maybe the 1 week, because I would anticipate that his probable cause conference in that matter would be set for next Thursday.
Well, maybe. Okay. Where's Ian? Oh, why are you there? Where's the other one? Where'd she go? He's supposed to be in here when I need him. Hold on a moment, folks. We have some disruption in the office. You don't know. Okay. Do you know if all of the paperwork has gone through regarding the new case?
I would hope so, Your Honor. I know the swear-to took place yesterday.
Did. Okay, so hopefully the paperwork. So can we let them know to set this for the 30th? All right, so I'll adjourn these out next week. And that other one, let that catch up.
Perfect.
Okay?
Yeah.
So I'll adjourn these to April 30th. All right? See you then.
Thank you, Your Honor.
Court calls case, people versus Tawan Edison.
You know, Raymond Show for the people.
Hey, Judge. Board Show Feaster, Assistant Public Defender on behalf of, Edison. I've called that name here in the courtroom in the hallway, Your Honor. I don't know if he's on Zoom or not. All right.
Negatory.
For the record, Judge, I do not know why they are not present. I will be requesting an adjournment, but I do not know where they are.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of 10,000 cash. The warrant will issue immediately. The court does call the case People versus Coloni Franklin.
Traffic here, I can top of Ms. Talani Franklin. One state your name for the record, Talani Franklin.
Thank you. Really? All right, no. That you'd be out of these by then.
I signed that, right, Judge?
Okay, especially an adjournment.
That's correct, Your Honor. There were just some videos that we saw online that we wanted to review with Ms. Franklin.
May 14, 2026, 9 a.m.
Thank you, Judge.
Round will continue. Thank you, ma'am. You're back. Oh, hey. Hi, no, don't worry about it. Nice to have you back. Court calls the case. People versus Zachariah Haruskadate Ennis.
Jacob Kennedy for the later on.
So, anyway. No, okay, whatever.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Dennis, I'm sorry.
Her name?
Dennis, Your Honor.
Thank you.
We're requesting an adjournment for some additional, for ongoing discussions and an opportunity to do some mitigation.
He's in circuit court on a bunch of other things, right?
But
He was, but not now.
yeah, led to those cases back in February.
Got it. Okay.
We would also like to request an opportunity for him to go to substance abuse treatment court.
Pardon?
We would also like to request an opportunity for him to go to inpatient substance abuse treatment, if the court would be open to that.
What's the people's position?
Your Honor, I certainly understand the court's general policy on this inpatient treatment as we got over this in the court. That during the last case, the defendant was listed as left inpatient treatment. That's right. Given those facts, given frankly how close we are to the last plenitude case, I wouldn't check this case.
You learned your lesson, haven't you? Will stay in treatment.
Yes. Probable cause conference will be adjourned May 7th, 2026, 9 a.m. I will not allow release to treat. In this case, I do recall that.
Okay, thank you.
Court calls case. Versus Dallas Fritz. You'll have to leave, sir.
You're welcome.
Yeah, this is on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellingham, Rich, in appearance via Zoom. It looks like, Rich, can you?
Yeah,
your name
hello,
correct?
how you doing? Dallas Fritz, Your Honor.
Thank you. I have before me a plea form that indicates that he's going to be pleading to count 3, the malicious destruction, pleading no contest to the charge of malicious destruction of personal property, 200 to 1,000, a 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution and continue with his substance abuse treatment. That's the court's full understanding of it.
For the people, Your Honor, yes. Of course.
That is also our honor.
All right. Mr. Fritz,
Yes, Your Honor.
can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Dallas Fritz, Your Honor.
All right. You can put your hand down. Sir, court's understanding that you're going to be pleading no contest to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. Fine could be increased if the times of value of the property taken. If that's greater than or destroyed, if that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right. Well, 2 things about a no contest plea. I have to make sure that you understand. First thing is, why is my screen doing this? The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Basis for no contest plea.
Pure potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
Guilty, Your Honor.
Really?
No contest.
Sorry, yeah, no contest. I didn't know. I had to specify and say that.
No,
Sorry.
that's okay. We got you straight. All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed or had someone sign an advice of rights form on your behalf?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
You understand you're waiving all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, sir.
Were you on probation at the time of this offense?
Yes, sir.
All right. You understand that your plea in this case could be a violation of that probation.
Correct. Yes, sir.
And you understand that as such, that other court could sentence you to the maximum allowable under those other under that other charge or charges. You understand that?
Yes, sir.
And understanding that, do you still wish to plead to this charge?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. The court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-68296. Any objection to the court having reviewed that report?
No, sir.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis which the court could determine the defendant's guilt of this offense. So I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 28, 2026, 10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond.
Thank you, sir.
Thank you. Bond will continue with its condition.
Thank you.
You're welcome. Good luck to you.
Thank you, sir.
Court calls the case. People versus Marcus Jones.
Judge Phelps for the people.
Ready, Judge? Court shall please to Assistant Public Defender on behalf of Mr. Jones, who is approaching the podium. When you arrive, Mr. Jones, please state your name for the record.
Your name, sir?
Marcus Jones.
Thank you. Thank you, Judge. We're trying to move this case forward. If we could set this matter for preliminary examination, please.
Discovery is complete.
To my knowledge, Judge.
And people have their witnesses available the 5th.
We will try for that date, Your Honor. Thank you.
All right. Preliminary examination in person, May 5th, 2026, 9 a.m. before 10 a.m. 10 a.m. before, really? Before Judge Fresh Hour.
May 5 at 10 a.m.
Yes.
Thank you.
Up to the hand. Thank you. Bond will continue.
Thank you, Judge. All right. Oh.
No. Court calls case. People versus, you need to keep moving. Court calls case. People versus Corey Falk. Thank you.
On behalf of Falk, who's standing to my right at the podium, please state your name for the record, sir.
Corey Falk.
We have began the mitigation process, and I believe there's some lab reports we're still waiting on. We'd be asking for a 3 or 4 week adjournment, Your Honor.
Madam Judge, probable cause conference, May 14, 2026, 9 a.m. Bond continue.
Thank you, Judge. My company.
Court calls case. People versus Ashley Nate.
Your Honor.
Greg Dean, Senior Assistant Public Defender with me, Ms. Nader. With the
Ashley Nader.
Your Honor, we're asking for a preliminary exam in this matter.
People have their witnesses available the 5th. Discovery is complete.
That's my understanding, Your Honor.
But we'll set a preliminary examination in person, May 5th, 2026, 9 a.m. before Judge Perry. Bond will continue. Thank you.
Thank you. Thank you.
Court calls case. People versus Darius Brady.
Assistant Public Defender Jay Bellinger on behalf of Mr. Grady, who approaches.
Can
Can you state your name for the record, Mr. Grady?
Darius Brady. Thank you. He's waiving.
Yes, Your Honor.
So you're waiving your right to a preliminary examination? Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
You will also waive their right.
Yes, Your Honor, and there is an offer on this case.
Go ahead.
The offer is to plead as charged with prosecutor's side of sentencing agreement to 5 years probation and no contest of non-individual defendant's siblings.
Yeah, that a correct statement.
That is a correct statement, Your Honor.
People do waive the
Yes, sure. Thank you.
preliminary examination having been waived. Defendants bound over to circuit court on a single count.
Acknowledge receipt of information, wait formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 23rd at 1:30 with Judge Conkey.
June 23rd, 2026, 1:30. Judge Cook.
Thank you very much.
You bond will continue.
And we'll be in touch with you before that date. I'll be in a different club, okay?
All right. I think I have it.
Yep. Something.
Court does call the case. People versus Sheriff McNally.
Morning, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Ms. Nally. Approaching, can you please state your name for the record?
Shereen Alley.
Thank you.
Your Honor, we do respectfully request this be set for preliminary examination.
Discovery is complete.
To my knowledge.
You will have the witnesses available the 5th.
We will track that, Your Honor.
Preliminary examination in person, May 5th, 2026, 10 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus David Grayson.
People.
Hello. Deputy.
Hello. Apologies, Your Honor. I did not hear the name I thought I heard. Public Defender Davi Liba for Mr. Grayson.
Mr. Grayson, can you state your name?
David Grayson?
Sir.
And Your Honor, there is a new case. I've been advised that we're going to be waiting to catch up.
It's your waiting to catch up?
I'm requesting to adjourn to wait to catch up.
Okay. Anybody have any other information on that for me?
I will pull it up here momentarily, Your Honor.
I've been advised that it's some sort of property crime, but I don't know any further details.
That's a big category.
Authorized it last Friday, so I will follow up with the Sheriff's Department to there be a bond violation.
Pardon?
It is not going to be a bond violation, but it
Got
is.
All right. So let's see if we can get those together. If they happen to get that, what I'll do is I'll set this for May 7th. So, right, 2026, 9 a.m. All right. And so therefore his bond will continue. Thank you, sir.
Thank you.
Court does call the case of the People versus Patrick Rowe.
People.
Morning, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Rowe, who is approaching. Can you please state your name for the record?
Patrick James Rowe.
Your Honor, we'd be requesting an adjournment for further discussions with the people.
Just the only thing holding it.
Yes, Your Honor.
Probable cause conference will be adjourned May 7th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Eric Jackson.
Action calls for the people.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Jackson.
Your name, sir? Eric Jackson. Thank you.
Your Honor, we are asking for an adjournment from Mr. Jackson for ongoing negotiations.
Adjourn the matter May 14th, 2026, 9 a.m. Bond continued.
Mr. Jackson, May 14th. Thank you.
Court calls case People versus Justin Taft. Your name?
Assistant Public Defender Davi Liba for Mr. Taft.
Name, sir.
Justin Tax.
Thank
Your Honor, we're going to be requesting adjournment in this matter. He has some other matters out of Genesee County. His attorney there is trying to get him into that veterans court program. And once we have an answer there, I'm going to be attempting to see if we can resolve the matters together.
Okay, I get you. But how long is that? Do they indicate the process? Because he hasn't been screened.
They indicate to me it'll be about a 30-day process.
Is this the only thing holding him here?
It is, Your Honor, and I was going to request a release to treatment.
Are the people going to have any objection to a release to treatment?
Your Honor, this time I would. He originally failed to appear in 2022 and was gone on bench warrant for several years. And now is back before Your Honor with 2 new cases in Genesee County. I have concerns about him coming back.
What are the other cases in Genesee?
That I don't know. I can certainly find out. He has indicated to me that the VA has told him, and they've indicated this to our office as well, they would have a bed for him at a residential treatment facility in Detroit.
All right. Well, what I'll do is I won't authorize it now, but I'm going to put this out. If between that time the parties could talk, because obviously he needs treatment. And I understand he'll get that into the veterans court if he's accepted, but if we can start that process earlier, I think that might be a better thing.
I agree.
All right. So I won't order it at this point, but I advise the parties to talk. And if the defense believes that there can be certain safeguards placed on and he's at the VA, you can file a motion for the court if necessary.
Thank you, Your Honor.
All right. Sir, what branch?
Army, sir.
Army. I won't hold that against you. All right. Shay wants 30 days out. Is that? I'm doing. May 21st. (2026) at 9 a.m. This bond will continue with this. Next, sir. Courthouse case, People versus Quinte Jenkins.
People. This is another convention of the Carrier on behalf of Mr. Jenkins, who is approaching.
That you were done.
Not yet, Judge. I'll be here till 2:00.
Joy.
This bigger. If you're asking for an adjournment, we just have to review some video footage with our.
Turn it to May 14th, 2026. Bond continued.
Thank you, sir. Okay.
Courthouse case, People versus Harold Watkins.
People.
Assistant Public Defender Davi Lee.
Forgot your name.
I'm just Watkins.
Oh, okay. Out there. I didn't know if it.
I thought he was behind me.
Okay.
Assistant Public Defender Davi Lee with Mr. Watkins. Mr. Watkins, can you tell the court your name, please?
Harold Watkins.
All right.
Here's the forms.
What are we doing?
We do have a plea agreement. I reviewed these forms, the vice rights and plea agreement with Mr. Watkins, and he's signing them right here.
Let my staff know?
Unfortunately, I did not, Your Honor.
And Your Honor, that's partially my fault. I would to
No cover for legal.
one that I wanted to get this.
Yeah, there is.
I apologize. Your Honor.
Still legal's phone.
Absolutely, Your Honor.
I can tell the court what the plea is.
Sure. Well, that's a phone's coming in.
Very good, Your Honor.
Did you state your name, sir?
Harold Watkins.
I have before me the plea form that indicates that the defendant is going to be pleading to the stated count 2 of operating with the presence of a controlled substance, the 93-day offense, and also an added count 4 of use of cocaine. the 1 year offense. Upon a successful plea to those two charges, well, no, something's wrong. The form indicates that count 1 and 4 would be dismissed, but that's not right. It's
It
1
should be
and
1 and 3. My apologies, Robert.
Counts 1 and 3 would be dismissed. That's the court's full understanding of it.
That is our understanding as well.
Likewise, Your Honor.
May I have him sworn?
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Harold Watkins. Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Correct.
First charge is the stated count 2 of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. So you understand that? Yes. All right. And also that you be pleading to an added count 4 of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand? Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
So you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses? May 18, 2020, at the location of Adams near Catherine, city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested cocaine?
Yes.
All right. Were you stopped by the police?
No.
Was there an accident?
No.
What happened?
I pulled the car over and parked and went to sleep in the car.
Okay, you pulled the car over when you were asleep in the car?
Right.
Was the car running?
Yes.
All right. Police arrived at some point?
Yes.
Woke you up?
Yes.
Took you to the hospital?
Yes.
Was there a blood draw?
Yes.
And did that blood draw result in showing in your blood, your blood, either cocaine or its derivative?
Yes.
Do you have any reason to dispute those blood test results?
No.
All right. And at the time you used the cocaine, you knew what you were using was cocaine.
Yes.
Sir, I do have to apprise you that if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir? Yes. All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 6th at 10 a.m.
May 6, 2026, 10 a.m. before Judge Barr.
Thank you, Your Honor. And bond, respond.
Pardon?
May I respond? Thank you, Your Honor. Mr. Watkins tells me that he could stay at an address in Ypsilanti with his sister. We have no objection to GPS tethered to assure his appearance. He tells me that he regrets his previous failure to appear and that he had returned to Michigan with the intention of resolving these matters when he was picked up at a traffic stop, and that he will stay in Michigan until they're resolved.
I'm going to deny any request for a change of bond given the failure to appear, but also I'll leave that to Judge Barr's wisdom after there's an assessment on the case.
Thank you, Your Honor.
Time it's denied. All right, thank you. Clerk calls case, People versus Levon Jones.
Assistant Public Defender Davila before Mr. Jones.
Good morning, Your Honor. Levon Jones.
Thank you, sir.
And Your Honor, will be requesting a preliminary examination, please. Discovery is complete.
And would people have their witnesses available the 5th? Preliminary examination will be set May 5th, 2026 at
And Judge Perry.
9 a.m. with Judge Perry.
Thank you.
All right.
Thank you.
Thank you, Bond. Continue. That's in person, sir.
Okay, thank you.
Thank you. Clerk calls the case, People versus Jason Westlake.
And then on behalf of the people, your honors.
Troy Gaines, public defender, is on behalf of Mr. Westlake. Would you state your name when you get to the podium, sir? You can say your name.
Oh, Jason Wesley.
Thank you.
Your Honor, we're requesting a preliminary exam.
All right, discovery is complete.
That's my understanding.
If I can respond.
All right. People would have their witnesses available on the 5th. Preliminary examination in this matter will be set for May 5th, 2026. It's at 10
Yes.
a.m. before Judge Freshour. All right. Esteban.
Your honor, it's come to my attention that post ran the defendant made 10 complete calls to the victim's listed number in this court and the number that our office has been using to contact her and have made her through. He also had 142 incomplete attempts to contact that number. In these calls, he tells her things as if she doesn't come to court, it'll get dismissed. I also want the court to note that he has, is on parole for a DV third and interfering with electronic communications with the same victim, which I believe also has no contact provisions within it. So prior to her, he was also violating that bond, saying that you want me to go back to prison. When she starts talking about the case, he said, you're really going to say that on here. And things of that nature. I was high, talking about my case, telling her that I talked to a lawyer, they said she was coming to court, it'll get dismissed talking to the victim. So at this point, I'm going to ask for phone and text privileges to be revoked, given that he's now violated these bond conditions and his parole conditions for that DV case involving the same victim.
Any response? Ms. Gaines, you may want to push the button on.
Oh, thank you, Your Honor.
I was talking to him before. Yeah.
And I also know for the court, these are from distant.
Who sneezed? Was it Danny those? Bless you.
Yeah.
All right. Thank you, Your Honor. I had a brief opportunity to explain to Mr. Westlake that his communication privileges will probably be revoked. So he is aware of that, and we are ready to move forward.
All right. Given what's been placed on the record, I will revoke the defendant's phone and text privileges. And otherwise, we'll continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Lamine Kaba.
That's felt the people.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs with non-PCOP, Mr. Kaba, who I did expect to be here in person, Your Honor. Is he
really
on Zoom?
Negatory, Ghostwriter.
Your Honor, I would ask for this matter to be passed because we did have a plea agreement reached today going into the health treatment.
Wow. Yeah, go ahead. What? He's not going to come in the door.
Your Honor, I did speak with him just yesterday and he did indicate he was coming in person, and I have concerns he may have gotten confused between this court and the Fifth District Court, because I know previously he had been observing the mental health treatment court at 15th.
Just talk, I'm gonna give it in. Go ahead, I'm listening.
Your Honor, we would just ask that I briefly
Okay,
pass
fine, I'll pass it and call it up in the next block.
you, Your Honor.
I don't know why I gave in to her. Court calls the case, People versus Preston Kelly.
Morning, Your Honor. Assistant Public Defender Davi Lipa for Mr. Kelly. Mr. Kelly, can you tell the judge your name, please?
Preston Kelly.
Thank you.
And Your Honor,
Study practice.
and Your Honor, we'd like to set this matter for preliminary examination, please. Discovery is
Discovery is complete.
yes.
People have their witnesses available the fifth.
Your best, Your Honor.
Preliminary examination will be set May 5th, 2026, 9 a.m.
Yes, sir.
before Judge Perry.
Thank you, Your Honor.
Bond will con-
Now you can go.
bond con- bye. Court calls the case, People versus Kaylee Loveday.
People.
Your Honor, public defender. Your Honor, pardon me, Ms. Loveland. He has been called in the courtroom in the hallway with no response. We would be asking for an adjournment in order to establish contact with our client. If you would, is it a sheet?
I don't need that. I'm good. Bench warrant will issue for defendant's failure. Bond is set in the amount of 10,000. Thank you. Nice try, though. Court calls the case, People versus Caleb Mark.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Martin, who approaches, Your Honor. Martin, can you please state your name for the record?
Caleb Andrew Martin.
And Your Honor, I am just seeking a brief adjournment on this. I am still waiting on some body worn cam in this matter. We also opened an investigation in our office on this matter, so it might take a little bit of time to get some of the information I'm looking for.
May 14th work for it?
I think that'll be fine.
All right. Probable cause conference will be adjourned May 14th, 2026. Oh, what are you doing? Never mind. May 14th, 2026, 9 a.m. Bond continued.
Thank you very much. Good to see you today, Your Honor.
Huh?
Good to see you. That's it for me today.
Okay. Here, sir.
Thank you.
Oh. Court does call the case, People versus Eric Mayfield.
And good afternoon, Your Honor. Assistant Public Defender Alexis Earps with and on behalf of Mr. Mayfield, who should be present on.
Mayfield.
Your Honor, we were just going to ask for an adjournment anyway to continue plea discussions with the prosecutor.
Mayfield.
Not unmuting, Your Honor. I'm guessing.
What?
Not unmuting. He's there, but not.
I don't know what he's doing. Mayfield.
Perhaps we pass this one to Your Honor and I can get a hold of Mr. Mayfield. Since I already have another one.
Fortunately. All right, I'll put that over with her other one, but her clients will go up.
Thank you, Your Honor.
You're welcome. That block. That's it. All right. You ready, me? Oh, you ready? No, I just want to make sure. Surprise. Court stands in recess.
Okay, guys, can you log in here, please? Ali Abdullah Ahmed, 25T6470779A and B. Who's his lawyer?
Mr. Warbling?
Okay. Mr. Warbling, I need you, sir. Do you have anything else down there? People against Goach, Rebecca Juliet Goach, 26G306936. Good morning, your name?
Rebecca Gosh.
All right. Okay, next, I'm gonna set aside the default. You gotta be more careful next time, okay? All right, so you went into default and you met with the department rep and they are going to offer you impeding traffic, correct?
Correct.
To that charge of impeding traffic, responsible or not responsible? Let me just review something here. All right. How bad's your record?
I think it's bad.
All right.
Officer out there told me it was okay.
Take that conviction off, Heather. Take conviction off from the March 6th incident. That's the one we're here on. Default judgment set aside. Plea to impeding is accepted. 165 is your total. You've already posted a bond in that amount. Is that in your name?
Yeah.
All right, just go down the hall and take care of that with them, okay? Cashier, good luck. Harrison, Amanda Marie Harrison, 26G306971. Your name, ma'am? All right, so you are going to plead responsible to impeding traffic, correct? To that charge, responsible or not responsible? Okay, I'm going to accept your plea to that. Let's see. 160 is your total, okay? Right down the end of the hall to the cashier, all right? Thank you. Hewer. People against Austin Lee Hewer, Sensing, 26T648102. Could I have Tillery seated up at the table here, sir? Your name?
Austin Hewer, Sensing?
You're charged with driving on a suspended. You have the right to an attorney. Would you like one?
Yes, please.
All right, we'll set you up with a lawyer. You can go out in the hallway and you're all set, okay? Tyler, either way, you're coming back in front of me. Tyler Keith Tillery, 26G306839, A, B, and C. Your name?
Tyler Tillery.
All right, so you have an operating while intoxicated. You have a violation of restrictions on license and refused PBT. You have the right to an attorney. Would you like an attorney? All right, you are 20 right now, correct? All right, go out in the hallway. We'll set you up with a lawyer. Mr. Werbling, come on in if you would. Ali Abdullah Ahmad, 25T647 with 79A and B. Do we have anything else down there?
This one needs an attorney too.
Yeah. Alexander Madrigal, 26G306740A and B. Your name? You're charged with operating while intoxicated. You're also charged with speeding. You have the right to an attorney. Would you like one?
Yes.
We'll set you up with a lawyer. You can go out in the hallway and we'll see you back here. Okay?
Thank you, Your Honor.
Thank you. Galen, you can come up here if you want. You can come in the jury box. Okay. Anything else down there? People against Murda, Jason Thomas Murda, 26T6481003A and B. Your name?
Jason Murder.
All right, you're charged with driving on an expired license and expired plate. You have the right to an attorney. If you want, I'll give you a lawyer. Otherwise, I'll arraign you and let you go talk to the prosecutor.
Oh, yeah.
Okay, so you're going to waive your right to a lawyer?
Yes.
All right, it is alleged that on March 20 of 26 that you did operate a motor vehicle with an expired license on Sibling or Quarry in Trenton at 8:13 in the morning. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs, or all those in 2 points. You understand that?
Yes.
You also have a second charge, civil infraction of expired plate. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we will not have a hearing or a trial of any kind. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
$100 personal bond, not guilty plea. I will enter a not guilty plea, give you a personal bond. You don't post any money, but you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You go out in the hall, that's going to the prosecutor. Prosecutor will call you in. You'll go talk to him. Either way, you're coming back in front of me. Okay?
Thank you.
Thank you. Is Priority Waste here yet? Heather?
No, she is not back yet.
All right. And Mr. Rahman's not back. And Mr. Werblin?
No, I'm not sure where they are. They're out here. I'm not sure what's going on though.
Not either. Okay. Are you you're not going to drive now. Come on. Mr. Werblin, give me a break.
I'm not driving, Your Honor. I've been parked here since 8:30.
Ali Abdullah Ahmad, 25T64707-9A and B. Is that Mr. Ahmad next to you?
That is, Your Honor.
Your name, Mr. Ahmad?
Yes, sir.
Can you state your name?
Ali Abdullah Ahmed.
Mr. Werblin, your appearance?
This is for your back 648.
I can't hear a word you're saying. You're cutting in and out.
Right.
Can't hear you, Mr. Werblin.
I don't know if it's any better.
Where are you?
I don't know if that's better, Judge.
I can't, you're frozen. Where are you right now? Where are you? Heather, go ahead and reschedule this. We'll take, is it May 7th?
Judge, we can do 9:45.
9:45. They shouldn't be in cars. Put no cars on there, will you please? May 7th at that time. And we'll go from there.
Okay.
That's what happens when they're moving around. I get lousy connections. So May 7th, 9:45, you can chat with them and tell them that's what I'm doing. Is Ms. Trombley out there yet?
Not yet.
All right. Detective Robinson, you have one for me?
I just had informal.
Okay, that's what I'm.
Market rep.
Thank you.
Reno.
All right, people against Tyler Michael Reno. Tyler Michael Reno, 26G306967. You don't, I know he was going way over. What's your name?
Tyler Reno.
Why are you driving like a maniac?
Oh.
Huh?
Pierce Baby.
Was he respectful? Come on up here. Your name?
Detective Robinson. He's been respectful of me. I don't know anything about the traffic stop.
You don't want to give him impeding?
I seen a citation just a month ago. Sounds like it was window tint. I just talked to him. I'm currently selling my car.
Let me see him. Can you bring,
I'm not sure if the court will allow it because of the previous citation there.
bring him up, Heather, or Sadie? Can you bring his name up? Tyler Reno. What are you driving like that for?
Honestly, not too sure.
How old are you?
I just turned 19 last week, sir.
Did you graduate?
Yes, sir. I graduated from Taylor.
What are you doing now?
I'm a travel electrician.
What was the original charge on that 26R5145 4-2. Can you pull that up and see what the original charge was? What are they? 6-10 over. You just got one. Why are you driving like this?
I don't know, sir.
You want
After
to,
those two,
pardon?
I've been doing the skateboard and stuff like that. Just not driving.
I know, but you're going 70 on Jefferson. Come on. I don't mind if you do impeding. He's going to pay some money though.
Okay.
You want to do impeding or not? If you don't, that's
In addition to the license suspension that's required, I do have an updated jail time credit of 61 days for Mr. Reed Miller.
Anything from probation?
No, Your Honor.
Mr. Kirby.
Thank you, Judge. First off, we want to thank the court for setting this out for sentencing. We have a statement that Ms. Young, who's present in the courtroom, would like to make. She's the fiance of Clint. Judge, Mr. Reed Miller is 51 years old, and he acknowledges he is too old for this. He is giving up this life of crime. He takes responsibility for his actions here. This was just a stupid mistake that he made by fleeing from the police. Fortunately, there was no accident here, no injuries caused to anybody. Your Honor, upon his release, he intends to reside in Brown County, Ohio. He believes he has a job waiting on him from his former employer, Bill Wallace, for a tree removal company. Your Honor, his lights were activated during this failure to comply. But again, this was just a regrettable decision. We'd ask the court to go along with that joint recommendation. That's all, Judge.
Thank you. Ma'am, anything you'd like to say? Identify yourself for the court reporter.
I'm Felicia Young. I'm his fiance, and when he comes home, we have a family property, and like I'm gonna support him, like and he has a lot of support with my family and everything now. So I don't know what else to say, but
okay. All right, thank
you.
Mr. Reed Miller, is there anything you want to say?
Other than this is a foolish mistake on my part, Your Honor, and this shall not be repeated at all in any shape, way, or form. And I am getting too old for all this, and this is going to be the last go round that Warren County is ever going to see of me again, other than maybe paying my child support, Your Honor. And that's pretty much it.
All right, the court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So the court will order you to serve 24 months in prison. You have 61 days jail time credit. Your operator's license is suspended for a period of 5 years effective today. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a mandatory period of post-release control. Upon your release from prison, the Adult Parole Authority will supervise you for up to 3 years, but not less than 1 year. If you violate those rules of supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Ms. Tranter, anything else?
No, sir.
Mr. Kirby?
There you go.
All right, good luck to you, sir.
Thank you, Your Honor.
It's okay. Why don't you change that in? Mr. Reno, slow down. Where do you work?
I work for a small company out of Rochester Hills. It's called Phillips Security. We're like a travel local electrician company.
A local what?
It's Phillips Security out of Rochester Hills, like travel local electrician company. So we travel throughout Michigan and Ohio, and Indiana sometimes.
You gotta slow down.
Yes, sir.
Charge impeding, responsible or not responsible.
Responsible for.
Responsible.
What would you say?
Responsible.
175, please accept it. You better slow down.
So, thank you very much.
All right, good luck.
Yep. Thank you.
Thanks.
Thanks, sir.
All right, what do I got now? Anything else? Nothing else? People against Loretta Ann DeVol, 268-2677, and could I have seated up here Jason Murda in that table right there? Ma'am, your name?
Loretta.
You're charged with a misdemeanor of failure to respond to two civil infractions. So that has become a misdemeanor now. You have the right to an attorney. Would you like one?
Yeah.
Okay, we'll give you a lawyer. Go out in the hallway and we'll, either way, you're coming back in front of me after you meet with the lawyer, okay? People against murder, Jason Thomas Murda, 266-48103 A and B. All right, your name, sir?
Jason Murda.
So you're going to plead to impeding traffic and they're going to dismiss the expired license and expired plate. Is that right?
Yes.
Wow, should have been a lawyer, huh? To the charge of impeding traffic, responsible or not responsible?
Responsible, sir.
All right, I'm going to accept that plea, dismiss the expired plate. I'm going to dismiss the expired license on motion of the prosecutor. Fines and costs are $175. You can go down the hall and take care of that, okay?
Thank you, Doc.
Best of luck. All right, what else do you have? Anything? Okay, come on back. We're gonna stay seated, everybody. If you want to bring Halen back, you're welcome. Come on in.
Plead guilty
Yes.
to the charge of attempted resisting and obstructing a police officer as contained in count 4. How do you plead?
Guilty.
To that same charge as contained in count 5. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
No.
No.
Could you repeat
Did
that?
somebody go through with you an advice of rights form?
Yes.
All right. And did you give them permission to sign your name to it after they went through it?
Yes.
All right. Do you have any questions regarding those rights?
No.
All right. You understand that you're waiving or giving up all of those rights?
Yes.
All right. Are you on probation?
No.
Are you on parole?
No.
You understand also that you're giving up your right to appeal of right?
Yes.
All right. Has anybody promised you anything other than what's been said here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. And also because you believe that you are indeed guilty?
Yes.
January 25th, 2025, at the location of 428 Alston Court in Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with two sheriff deputies?
Yes.
All right. Man. I think they were. All right. When you came into contact with the sheriff's deputies, what happened?
I came into contact with them and then I tried to go use the bathroom. Well, I acted like I was gonna use the bathroom. Then they try to come in to the bathroom with me to try to do their job, and then I resisted. I got tased, and I mistakenly held the towel rack, and it came out. So it came out the wall, and that's what happened. I got arrested.
Okay.
And
Did you?
Yeah.
All right. Mr. Cabot, at the time that you were trying to leave, did they told you to stay where you were, and were they trying to arrest you at that point?
No.
No?
No.
Okay, what'd you do that caused them to tase you?
I think I was resisting.
Okay, when you say you were resisting, what were you doing?
I tried to close the door on the police officer's foot because he tried to put his foot in the door. Then I tried to
Okay, so
shut
he
the
tried to
door.
put they wanted to talk to you or something along those lines, right? And you put your foot in the door so you couldn't close, so they couldn't close. Well, they put their foot in the door so that you could not close the door, correct?
Right.
Okay. And then you resist. They then tried to arrest you at some point, correct?
Right.
And then you did things that resisted that arrest. Is that correct?
Yes.
And that led them to have to tase you. Is that right?
Yes.
Okay. And there were two officers there at that time?
Yes.
All right. Sir, let me just tell you that between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules. You would not be entitled to withdraw your plea, and any sentence evaluation or recommendation the court would no longer be bound by. You understand that?
Yes.
Counsels, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied and would like to just make a record that at the original time of contact, the police officers were attempting to contact Mr. Kaba because he had left psychiatric emergency services earlier in the day.
Gotcha.
And they were trying to cooperate with a petition to bring him back to services. So he was not going to be subject to arrest necessarily, just to the execution of that petition. It's what the record to be clear about that. So we are satisfied with the court.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered to the extent it is at 15th District Court at Mental Health Court. And you had given us a sentencing date. Sentencing
April 29th at 1:30.
April 29, 2026, 1:30. That's as it was by the public defender.
That's with Judge Garwood.
And that is with Judge Garwood. Bond will continue.
Your Honor, may I approach for your signature?
So we have to keep this right. Will continue. First, court calls the case, People versus Eric Mayfield.
And good afternoon, Your Honor. Assistant Public Defender Alexis Serbs with and on behalf of Mr. Mayfield. Mr. Mayfield, can you please state your name for the record?
Eric Mayfield.
All right, what are we doing?
Your Honor, we have just requested an adjournment for continued discussions with the people.
Probable cause conference, May 14, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Court calls the case, People versus DeMarco Henderson.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Just in a second.
Mr. Henderson, can you state your name, please?
DeMarco Henderson.
What are we doing?
Setting for a preliminary exam.
Discovery is complete.
Come on, Alex.
Pardon?
Come on out.
And would people have their witnesses available on the 5th?
Do our best, Your Honor.
Preliminary examination in person will be set May 5th, 2000.
Sorry, Your Honor, I'm in a already paid for SCAO conference that day. 2 days, actually. Can I have another?
One different day.
Please?
Will the 12th work for you or
It will. Thank you.
objection from the people?
Done, Your Honor.
May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court calls the case, People versus Koisha Pitts.
Good afternoon, Your Honor. Christina Saxon for Ms. Pippins, who's approaching.
Allowed to leave?
Yes, Mr. Kaba, you can leave. Your name?
Koisha Pippins.
All right, what do we,
We're setting for preliminary exam.
discovery is complete?
Yes, it is.
And do people have their witnesses available the 12th?
Yes, sir.
Preliminary examination in person, May 12th, 2026. 9 a.m. before Judge Washington.
Thank you.
Thank you. Bond will continue. Court calls case, People versus Demetrius Caldwell.
And good afternoon, Your Honor. In rushing, appearing on behalf of Mr. Caldwell. Mr. Caldwell should be on Zoom. And then Mr. Caldwell, if you could state your name for the record.
Demetrius Caldwell.
Thank you. Your Honor, we did receive a report regarding Mr. Caldwell's competency. I did provide a copy to the court. So at this time, I think we're just asking that that be entered and set a review date for approximately 90 days.
No additional evidence from either side.
That's correct. There is no additional evidence from people. We ask the court accept the report from the Center for Forensic Psychiatry and stipulate to its omission of no additional evidence.
To indicate that this report, it does indicate, and the court has reviewed it, that the defendant at this time is incompetent to stand trial, but likely to obtain confidence. And counsel, I would need an order.
Okay.
For the court, please. I will set a review date. Thank you, because we can always move it up.
July 23rd.
Set a review date for July 23rd, 2026, 9 a.m.
Thank you so much, Your Honor.
You, bond will continue. Court calls case of the People versus Rachel Pichette.
And good afternoon, Your Honor. Sidney Rushing, appearing on behalf of Ms. Pichette. Ms. Pichette, if you could unmute your mic and state your name for the record, please.
Rachel Pichette.
And Ms. Pichette, well, I have before me a plea form. Is that what we're doing?
Yes, Judge, that is what we're doing today.
Form indicates that the defendant will be pleading guilty. Well, it doesn't say.
Yes, pleading guilty, Judge. Yes.
Pleading guilty to the charge. Use of heroin, the 1-year offense.
That's correct, Judge.
Upon their successful plea to that misdemeanor charge, count 1 would be dismissed. It is also the agreement, the defendant agrees to be placed on probation with drug treatment as a term of that probation and as deemed appropriate by probation or any designee. That's the court's full understanding of the agreement.
That is correct, Your Honor.
And that's correct, Judge. And we've had an opportunity to discuss her trial rights. She'd like to waive them, except the offer that the people have tendered.
Chet, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, state your name again for the record.
Rachel Pichette.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of heroin. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, I do.
All right. In understanding that, you still wish to plead guilty? Well, I
Yes,
do
I
have to
do.
advise you one other thing. Although I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Correct. Yes.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, not at this time. Thank you.
All right. You signed, actually, I'm going to need her to sign a misdemeanor advice of rights, signed a felony advice of rights.
Okay, Judge. We'll get that submitted to the court.
You understand that they're contained on the form, but not under paragraph 5. You understand that those rights that are on there, that you're waiving those rights.
Yes, I understand.
All right. Are you on probation or parole?
I am currently on probation in your courtroom with Miss Pilara.
Yes. And were you on probation at the time of this offense?
I'm not sure. Honor, this is from 2022.
It's from 2020.
So
Well,
no, I don't think so.
looks like they changed that to 2020. All right. And she still would be on probation to be at this time in either case, quite frankly. All right. You understand that you're giving up your right to appeal of right?
Yes.
You're not on probation, you're not on parole at the time of this offense. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. And also because you believe that you're guilty?
Correct.
On, looks like September 22nd, 2020, I think is the complaint has been amended.
Yes, Judge. I apologize.
Did you have heroin in your possession?
Yes, I did.
Had you used it?
Yes.
And did you know what you were using was heroin?
Yes.
All right, ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand, yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
People are satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
May 28th at 10 a.m.
May 28, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you so much, Your Honor. Thank you.
Here. Court calls the case of the people versus Nayeli.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Lee. I am standing in for her attorney of record, Attorney Costantino. Ms. Lee, can you unmute your mic and state your name for the record, please?
Nayeli.
And Ms. Lee, are you okay with me standing in for Ms. Constantino, giving you the adjourned court date?
Yes.
Your Honor, there is another matter that we are tracking, and there are ongoing negotiations. That other matter has a court date of May 5th, so we are just asking for a date after that date.
May 14, 2026, 9 a.m. Bond continued. All right. Thank you. Thank you, Ms. Lee. Court calls the case People versus David Shukai.
People.
And good afternoon, Your Honor. Sydney rushing in on behalf of Mr. Shukai. Mr. Shukai, can you please unmute your mic and state your name for the record, please?
Yes, ma'am.
Can you state your name for the record, please?
David Patrick Shukai.
Thank you. And Mr. Shukai, I am standing in for your attorney of record, Christina Constantino, as she is stuck in another courtroom. Are you okay with that?
Yes, ma'am.
Your Honor, at this time, discovery is complete and we'd like to ask for a preliminary examination date to be set. Any date works.
People have their witnesses available the 5th.
Do our best, Your Honor.
Preliminary examination in person, May 5th, 2026 at
10 a.m.
10 a.m. before Judge Freshour. Bond will continue.
Thank you so much, Your Honor. Great to see you as always.
Yes.
I told you I'd be in person. I came in person. I just want you to know.
Happy. All right, you're okay. You're all set, Mr. Shukai.
Thank you, sir.
Thank you. Court calls case People versus Emmanuel under Uruchukwu. All right, I was close. I think. All right, counsel, state your appearance, please.
Joy Mohammed on behalf of Mr. Uruchukwu. Emmanuel, please state your name for the record.
Emmanuel Uruchukwu.
Thank you.
Your Honor,
All right, what are we doing?
I asked for this additional PCC after a couple of weeks ago in order for an opportunity to fully address bond. We had a lot of different issues that we presented at our first PCC. We have a motion that is still outstanding, but my client currently has a GPS tether. We're asking for the court to consider removal of that GPS tether because it doesn't serve the purpose which bond is intended, which is to make sure that the community is safe and make sure that my client comes to court. He has no KPS history. This is a 3-year-old case. And during those 3 years, he had no interactions with the police whatsoever. And so there was an issue last time we discussed as far as what would be the exclusion zone. I don't know if the people have identified that exclusion zone yet. And if they have, I would like for that to be entered into a court order. But like I said, the current tether placement doesn't serve the purpose of what we as a community put people in tether for, and it's causing a financial burden on my client. He, is causing attention for him at work, putting his job in jeopardy, which he needs to pay for the tether. So we're asking for it to be removed.
Your Honor, I'll answer that in 2 parts, really. This is a criminal sexual conduct first-degree case involving a minor. The court would be well within its right to deny bond on this case based on that offense alone. I would simply ask to have it remain in place until the date of that motion hearing, so that this court would be fully apprised of what is going on in this matter. I did receive information from my victim's advocate about the exclusion zone the counsel was mentioning just yesterday. I did talk with court staff about the best way to get that over to you, but I'm going to do that this afternoon. I would ask them to remain in place. 5-7.
I took the home confinement off.
That's correct, Your Honor.
All right. And is there then going to be another motion before me?
There is an additional motion. Counsel Miller hearing that.
Right. Okay. All right. Well, other than what I had ordered previously, I don't hear anything that's going to necessarily change my mind. And counsel's right. I could deny bond, which I think would be absolutely inappropriate in the case, at least based upon what I know. But I don't think that the tether is necessarily inappropriate given the circumstances of the case. So I'm going to deny the request for any further change in modification of the tether at this time.
May I ask if the people have the can he clarify as far as what the exclusion zone, what's going on with that?
I have the addresses. I'm going to provide them to staff today.
I'm sorry, I didn't hear you.
He has the addresses. He's going to provide them to staff. Are you talking community corrections staff or?
Yes.
going to provide them to community corrections, and the defendant is notified, but we will not state those addresses in open court.
Thank you. That's fine. That's fine. All right.
Oh.
Thank you, Your Honor.
Thank you. So what I will do then is I will set this probable cause. Your motion is already here. It's set. So I'll keep the probable cause on that same date.